Your Honor, I think you're on mute. Are you talking to us?
I'm sorry, I'm on the phone with Phil trying to make sure we can figure out where our jurors are. I wasn't I was muted, but I was not talking to all of you. So sorry, again, we're just waiting on the two jurors, and hopefully we can get started soon, okay?
Yes, Your Honor. Thank you.
right, so we just had one more juror come. I'm not sure if we're going to get another one or not. I think they're just moving some jurors around, so that's what we're waiting on, okay?
Yes, Your
And
Honor. Thank you.
and the opportunity to get the all clear from Phil. All right, just to let you all know what's going on, apparently a number of rooms are having some issues, all right? So it's not just our room, and I think they're just moving some jurors around. I know that you're anxious to get started, but as soon as we're ready, we'll get going, okay? Sorry. I don't believe we're going to be getting another juror, but I still have not gotten the all clear, but I'm just going to do a conflict check just to make sure that none of the jurors know any of the advocates. So if you do, please just let me know, type a message or come on the screen. And if I don't hear anything, then I'm going to assume that no, you don't know any of them. All right, I just got a call. We should be 30 seconds and then we should get getting started, okay? Just waiting for one last all clear. And we just got the all clear. So I just have to read this. I know that you've heard it a number of times, but I'm supposed to read it to the jurors. So we just got the message to get started. We're going to call the case of State of West Carolina versus Timothy Ray. My name is Jared Hackliff. The scoring judges, they have muted their screens and turned off their audio. And please continue to do that until the trial ends. And that's it. We can start with appearances. Counsels, how are you today?
Good afternoon, Your Honor. My name is Alex Messmore, alongside my co-counsel, Ms. Elizabeth Wireman, and we represent the state of West Carolina in today's proceedings. Your Honor, we are team number 102, and we have prepared notices of appearance. If Your Honor would like us to drop a copy in the chat.
Oh, I can see on the screen. That's fair enough. Can I have defense's appearances?
Yes, Your Honor. We're Team 104. My name is Braden Hodak, along here with my co-counsel, Miss Jessica Allen, and we represent the defense, defendant Timothy Ray.
Good afternoon, counselors. All right, Madam Prosecutor, do you want to begin with any pretrial motions or any housekeeping that you might have?
Yes, Your Honor. We'll address housekeeping, and then my co-counsel, Ms. Wireman, will take up our motion in limine. Your Honor, may we assume that all witnesses are pre-sworn?
You may.
And Your Honor, at this time, the state would like to invoke Rule 615, sequestering all witnesses that are not experts or parties to this case. Specifically, Your Honor, we would like to exclude Dr. McLagreca from sequestration at this time.
Any issues with that, defense?
Constructively, no, just for the purposes of the competition.
All right, fair enough.
Your Honor, when making evidentiary arguments, may we assume that all sidebars are constructive and outside of the presence of the jury?
You may.
Your Honor, there are some stipulations in today's case. May we read them as they become relevant?
Please.
Yes, Your Honor. We also intend to introduce an expert, Dr. McLagreca, in the field of forensic psychiatry. When tendering this expert, would you prefer us to formally tender or simply lay the foundation and move on?
Formally tender, please.
Yes, Your Honor. When seeking to introduce exhibits in today's case, would Your Honor prefer us, or seeking to publish, I'm sorry, Your Honor, when seeking to publish these exhibits, would you prefer us to ask the first time or each time?
Just the first time.
Yes, Your Honor. We spoke to opposing counsel prior to trial and have stipulated to admitting Exhibit 4, which is located on page 45 of the electronic notebook, which is the Miranda waiver signed by the defendant, as well as Exhibits 6 and 7, which are respectively the autopsy report located on page 53, as well as the missing persons report located on page 54 of the electronic notebook. At this time, the state would like to introduce those into evidence.
Defense, you agree?
Yes, Your Honor. Exhibits 6 through 8 have already been pre-stipulated to per the rules of this competition.
Okay.
Yes, Your Honor. Pursuant to local rule, when seeking to admit evidence, we will be directing court and counsel to both the exhibit number as well as the page reference in the electronic notebook.
Very well.
And Your Honor, the state intends to introduce a demonstrative when directing Dr. McLagreca. We have spoken to opposing counsel, and at this time, they have no objections to the introduction of this demonstrative.
You're in agreement, defense?
Yes, Your Honor. No objections to the demonstrative.
All right.
And Your Honor, this time we have no further housekeeping matters to address, and we're ready to proceed with motions when Your Honor is ready.
Let me just ask defendants any other housekeeping issues before I hear motions to eliminate.
Yeah, I'm not sure if I heard prosecution ask you this, but the exhibits have been pre-marked for identification for the purposes consistent with the joint exhibit list, and I just want to make Your Honor aware of that.
That's fine.
And we have one motion to eliminate.
All right, I'm going to hear the prosecution's motions to eliminate, and then I'll hear yours, defenses.
Yes, Your Honor. At this time, the state moves in limine to exclude any evidence or testimony of the defendant's mother's alleged mental illness. This evidence or testimony is not based on reliable facts or data as is required under Rule 702. And its prejudicial value far outweighs its probative under Rule 703 of the Federal Rules of Evidence. Just a little background, Your Honor. In today's case, the defendant is claiming that on October 17th, 2018, when he strangled the life out of his 6-year-old son, that he could not appreciate his actions or he could not know that what he was doing was wrong. He is claiming that he has schizophrenia, Your Honor. The defense's expert or alleged expert, Dr. Riley, bases his opinion and his diagnosis of the defendant at least partially on this testimony or evidence of the defendant's mother's alleged mental illness. But all Dr. Riley knows about the defendant's mother is what the defendant's father, Abe Ray, told her. Abe Ray told Dr. Riley that the defendant's mother suffered from mood swings and was eventually institutionalized. But Dr. Riley has never evaluated the defendant's mother. In fact, he has never even met her or seen her medical records. No peers, not even from the institution or any of her supposed previous doctors, have backed that she was ever even diagnosed with any mental illness, much less schizophrenia. So the claim that they would make of the defendant's alleged mental illness being linked or inherited from the defendant's mother is not proper here, Your Honor. Of course, we understand that expert witnesses can base their testimony on inadmissible hearsay, but this evidence or testimony of the defendant's mother's alleged mental illness is not based on reliable facts or data under Rule 702 and would mislead the jury to believe that what Dr. Riley would say is true or should be relied upon. So it is more prejudicial than probative under Rule 703 of the Federal Rules of Evidence.
Okay, defendants.
Yes, Your Honor. Under Federal Rules of Evidence 703, evidence that otherwise may be inadmissible would be allowed in for the help for the jury to understand a expert's opinion. Specifically, if the expert in a particular field would reasonably rely on these kinds of facts or data in forming an opinion, they need not be admissible in court. As we will hear from Dr. Riley, her interviews were part of her investigation, and her interview with the father is something that she reasonably relied on in coming to her conclusion. Thus, we do find that it would be substantially more probative to help the jury evaluate the opinion of Dr. Riley. Now, while the prosecution would like you to believe that it would be more prejudicial or that the evidence would not be credible, that goes to the weight rather than the admissibility, and the trier of fact can weigh those options.
I'll give you the last word, Madam Prosecutor.
Yes, Your Honor. Again, this is not reliable evidence or testimony because it was not based on reliable facts or data, which is needed under Rule 702 of the Federal Rules of Evidence. And Your Honor, it is more prejudicial than probative under Rule 703 because the jury would likely think that this is true and that it was reasonably relied upon as is taken from the medical field. However, as we have already stated, Dr. Riley has no idea if the defendant's mother was ever diagnosed with any mental illness, making it improper to say that his opinion or test or diagnosis of the defendant could be relied upon, that the defendant's alleged mental illness could be linked or was inherited from the defendant's mother.
All right, so you're making a 403 argument and a 702 argument, correct?
Sorry, Your Honor, it's 702 with the reliable facts and data, and then 703, it's improper because its prejudicial value is outweigh. I'm sorry, it is more prejudicial than probative under 703 because of the expert's testimony. It cannot be relied upon.
Where did the doctor get the basis for the testimony, for his testimony? Where did he learn of this?
Yes, Your Honor. Dr. Riley only knows anything about the defendant's mother from a 10-minute phone call with the defendant's father, Abe Ray.
Okay. All right. I think the arguments have been made very well by both sides. At this time, I'm going to allow it into evidence. They do believe that it's something that the jury should make a determination on as to whether or not they believe it or they do not. You have an exception. Anything else?
No, Your Honor. The state has no further motions in limine at this time, and we are ready to proceed with opens when the court is ready.
Okay. Ms. Allen?
Yes, Your Honor. Defense has one motion in limine. May we give it forth now?
Please.
Defense anticipates that the prosecution may attempt to enter into evidence Exhibit 10. Now, Exhibit 10 is the defendant's search history the day after the alleged murder. We move to exclude Exhibit 10 under Federal Rules of Evidence 401 and 403. To be relevant, Federal Rules of Evidence 401 states that evidence must have a tendency to make a fact more or less probable. Today's case deals with first-degree murder. The prosecution must prove Mr. Ray's mens rea at the time of the incident. The incident occurred on October 17, 2018 at 7 a.m. Exhibit 10, does not show the day of the incident, but rather a day later. The search history does not go to show Mr. Ray's mindset at the time of the incident, but rather the consequences that occurred due to his mental break of reality. In addition, we do not know how long of a time span passed between the incident and the research. While we can see this research happen on October 18, we do not know what time the searches were completed. A whole 24 or even up to 41 hours may have passed. Too much time has passed for this search to be used to show Mr. Ray's mindset at the time of the incident. As the evidence does not go to show Mr. Ray's intent to commit murder, it does not go to show Mr. Ray thinking what Mr. Ray was thinking at the time of the incident. It does not go to show any evidence of the day of the incident, rather after the fact. Now, the council has charged Mr. Ray with first-degree murder and not improper disposal of a corpse, and thus Exhibit 10 is substantially more prejudicial than probative, and we ask to have it excluded.
I understand. Okay, Ms. Messmore?
Your Honor, we're here today on a murder case in which the defense is asserting an insanity defense, putting the defendant's mental state at the time of the murder in question. Your Honor, citing court and counsel to page 12 of the electronic notebook, in which the jury instructions read, "In making your decision, you may consider evidence of Timothy Ray's mental condition before or after the offense charged." Your Honor, the defendant's decision to search how to destroy a body, if bleach destroys a body, and what countries don't extradite for murder, go exactly to this defendant's consciousness of guilt. Your Honor, this testimony and this evidence is extraordinarily relevant for the jury to determine whether or not this defendant had the requisite mental state at the time of the killing and is due to be admitted.
Okay. Ms. Allen, any last words?
No, Your Honor, I just want to reiterate that this was after the fact. It does not go to show Mr. Ray's mindset at the time of the murder, which is what state has to prove. And because it doesn't show at the time, it's more prejudicial.
I understand. I do believe it's relevant under 401, and I don't believe that the 403 balancing test is at issue here. So I'm going to allow the evidence in. I believe the jury should be able to make a determination for themselves about it. You have an exception. Thank you very much. Any other motions by the defense?
With that, Your Honor, defense is ready to proceed to opening.
All right. With that, I believe I'm supposed to read one more thing. Okay. We'll now hear opening statements from both parties. Everyone should make sure that they are on speaker view. That button is on the right, upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking.
Your Honor, before we begin, the state would like to put this court on notice that under 704B of the Federal Rules of Evidence, as well as West Carolina law, the defense is not to go into ultimate issues of the defendant's mental state or condition.
Okay, I'm aware. If there's any problems or issues, you can make an objection and we'll deal with it then.
Yes, Your Honor. Thank you.
Thank you. All right. Madam Prosecutor, you may begin when ready.
Nathan Ray was a 6-year-old little boy. A 6-year-old little boy with years of soccer games and birthday parties ahead of him. A 6-year-old little boy with a future. On October 15th, 2018, his mother, Jessica Ray, hugged him goodbye before dropping him off at kindergarten, knowing that he would spend the next 2 days with his father, the defendant. So Jessica hugged Nathan goodbye, completely unaware that this would be the last time she would ever see her baby alive. Because just 2 days later, Jessica Ray's worst nightmare became a reality. She drove to Nathan's school to pick him up, but when she got there, Nathan was not there. She tries to call the defendant, but he does not answer. She drives to his house, but no one is home. The car, gone. Jessica continues to worry until she learns the truth. The truth that you will learn today, that her baby, her only child, her 6-year-old son had been strangled to death and tossed into a shallow grave by her own husband, Nathan Ray's own father, the defendant. Today you will learn that the defendant was calculated. He was controlled, and he was committed. On October 17th, Nathan was sitting at his dad's kitchen counter. He was eating breakfast, drinking juice, But as 6-year-olds often do, Nathan accidentally spilled his juice. And with juice leaking all over the kitchen counter and the defendant's laptop, the defendant starts to scream. He orders Nathan into his bedroom, orders him to do jumping jacks, orders him to do high knees. And Nathan does his best, but his little body just cannot keep going. He starts to cry. But this does not matter to the defendant. He yells at Nathan, "Keep going, do not stop." Nathan looks up at his dad. He begs for forgiveness. At this point, his body aches, his 6-year-old mind unable to understand why his dad is so angry. For a moment, everything stops. Nathan peers out of his bedroom door as he watches the defendant walk out. He thinks, he hopes, he prays that this means the punishment is over. The defendant walks out of Nathan's bedroom into his own. He sits down on his bed and he pauses before grabbing his belt. He then walks back into Nathan's room, and this is when the punishment begins again. This time, the defendant beats Nathan over and over and over again with his belt. Nathan cries out for his mom, but this just makes the defendant angrier. He takes his belt, he wraps it around little Nathan's neck, and he pulls it tight. Minutes pass, but the defendant does not stop, squeezing his belt tighter and tighter, watching as the life leaves his little son's body. With Nathan's lifeless body laying there, the defendant begins to calculate. He grabs his phone, Googles, searching for ways to get rid of a body, searching, will bleach destroy a body, and searching for countries that do not extradite for murder. He is in control now. He grabs bleach, a shovel, and some trash bags. He wraps Nathan's lifeless body in a trash bag, and he tosses it into the back of his car. He then starts to drive. He drives to Brandywine State Park, where he starts to dig, digging his own son's grave, burying any proof of what he had just done, just as Google told him to. But the defendant's plan does not go off perfectly. He is later stopped at a DUI traffic checkpoint and brought into police questioning. This is where he confesses, he admits to murdering his 6-year-old son. Because of this, we have charged the defendant with first-degree murder. As the state, as the party bringing this charge, it is our burden, our duty to prove to you today, beyond a reasonable doubt, that the defendant not only murdered his son, but did so with what is called malice aforethought. You see, it is undisputed that the defendant brutally murdered little Nathan. So all we have to prove to you today is that on October 17th, 2018, the defendant knew exactly what he was doing when he took Jessica Ray's son away from her. To help us prove this to you today, you will meet 2 witnesses. Today, you will meet Detective Booth, the lead detective on Nathan's case. He will tell you that he did everything he could to make sure the defendant understood his rights and understood what was going on. Then he started asking the defendant questions. And this is when Detective Booth learned about the final moments of Nathan's life. This is when he learned exactly how the defendant killed his own son. And this is when he learned where to find Nathan's buried body. Prior to today, the defendant has brought an insanity defense. All this means is that he is claiming that on October 17th, he could not appreciate his actions, that he could not understand that what he was doing was wrong. He is claiming that he has schizophrenia, which is why today you will meet Dr. LaGreca, an expert in forensic psychiatry. Dr. LaGreca will tell you that the defendant, he never claimed symptoms of schizophrenia until September of 2019, nearly a year after being in prison for murdering his own son. Dr. LaGreca will tell you that the defendant was never suffering from a mental illness, but instead he is malingering, a fancy word that means he is faking his symptoms to try to get out of trouble or to create a legal defense. Dr. LaGreca will tell you that the defendant was never suffering from a mental illness. No, today you will learn that the defendant was calculated. He was controlled. And today he is committed to getting away with murdering his son. Which is why at the end of today's trial, my co-counsel Alex Messmore will come before you. And we will ask you to deliver the only verdict that the evidence supports and justice demands. Find the defendant guilty.
Okay, thank you very much, Madam Prosecution. Mr. Hudak, you ready to go?
Yes, I am.
All right, whenever you're ready.
May it please the court, counsel, members of the jury. You cannot stop what you cannot control. Timothy Ray could not stop his mother from developing a mental illness. Timothy Ray could not stop his mother from abusing him as a child. Timothy Ray could not stop the mood swings and mental breakdowns that forced the love of his life to leave him. Timothy Ray could not stop the fact that every single person that he interacted with missed the signs. And on October 17th, 2018, Timothy Ray could not stop the creepy voices that led to the death of his son. Timothy tried and failed because he could not stop what he could not control. Now, the state just got done telling you what Timothy Ray is. I would like to tell you who Timothy Ray is. From the age of 3, Timothy Ray has been fighting against the odds. While most children grow up in a loving and nurturing home, Timothy experienced the opposite. Instead, he grew up with a neglectful mother, a mother who, while suffering from mental illness, refused to feed her child, a mother who chose to bathe her child in ice-cold water, a mother that chose to abandon her child when he was just 3 years old. But even though his mother is gone, the effects of her abuse and neglect still remain. From the age of 10, Timothy began hearing voices that would come and go throughout the years. Timothy would attempt to hide these voices out of fear of being labeled crazy like his mother. But the voices persisted. As Timothy grew up, he even went on to try to serve his country. But despite his efforts to move on from his childhood, he was soon discharged after reports from his commanding officer that Timothy was suffering from anxiety, depression, and hallucinations. Timothy was once again left alone. Alone until he met the love of his life, Jessica Ray. The two met in 2011 and married soon after in 2012. Things were looking good. The two even gave birth to a young boy named Nathan. But even Timothy's love for Jessica and his son was not powerful enough to overcome his mental illness. Throughout their relationship, Timothy would suffer from mood swings, recurrent racing and negative thoughts, and visual and auditory hallucinations. Jessica would often plead with Timothy to get help for these mental problems. But despite her efforts, Jessica was forced to sit and watch as the person that she loved turned into someone that she could not even recognize. And after 6 years of marriage, that marriage ended. Now all Timothy has left is his boy, Nathan. But in the months leading up to October 17th, 2018, the hallucinations returned. Timothy saw triangles on the walls that changed shapes and colors. He heard a male voice that told him to hurt other people. And on October 17th, 2018, Timothy heard a creepy voice that told him to kill his son. And like that, the last thing in Timothy's life was taken from him. So who is Timothy Ray? Timothy Ray is a man in pain, a man that to this day is still grieving over everything this disease has stolen from him ever since he was a kid. A man forced to live with the mental disease that went unnoticed, untreated, and was therefore uncontrollable. Members of the jury, my name is Braden Hodak, and I, along with my co-counsel, Ms. Jessica Allen, represent Timothy Ray. Now, I'd like you to recall our discussions in jury selection when we talked about the burden of proof in this case, and how the state must prove to you beyond a reasonable doubt that Timothy Ray possessed hatred in his heart at the time Nathan Ray was killed. Imagine the burden this way. There's a set of scales in front of you. On one side sits an elephant, the largest one you can think of. On the other side is nothing yet. Now imagine someone putting rocks of various sizes on that other side of the scale and picture it move. The elephant never leaves the scale at any point in time. Timothy Ray is that elephant. He is innocent until proven guilty. And it is the state's burden to prove to you, and by placing rocks of various sizes or pieces of evidence, to tip the scales. And to find Timothy Ray guilty, the scales must lift the elephant so high that the other end of the scale is barely skimming the ground. Now, at the close of trial, my co-counsel, Ms. Jessica Allen, will stand before you. When she does, she is going to discuss with you the facts that we have discovered together, the law that the judge will provide. And she's going to ask you to look at the facts and look at the law through your own common sense. And we are confident that if you look at the facts and look at the law through your own common sense, you will be given no other option than to find that Timothy Ray did not have control, and that Timothy Ray is innocent, because he is.
Thank you very much, Counselor. All right, before we have the first witness called, I'm going to ask everyone to switch to gallery view. That button is on the upper right of your screen. This will allow you to see the attorneys and the witnesses at the same time. And with that, you may call your first witness, State.
Yes, Your Honor. At this time, the state calls Detective Booth to the stand. Would you please introduce yourself?
My name is Detective Blake Booth.
Detective Booth, where do you work?
I'm a homicide detective at the Skelton Police Department.
How long have you worked for the Skelton Police Department?
I've been there a while, about 23 years.
How long have you been a detective?
12 years.
Detective Booth, why are you here today?
I'm here today to testify because I was the lead detective in the Nathan Ray homicide investigation.
How did you become involved in Nathan's case?
Well, it all started, Jessica Ray, Nathan's mother, filed a missing persons report with the Skelton Police Department, and it was filed actually with me, so that was my first interaction.
Who was the suspect on that missing persons report?
Nathan Ray's father, Timothy Ray.
Do you see Timothy Ray in court today?
Yeah, he's seated at defense counsel's table.
Let the record reflect that Detective Booth has identified the defendant, Timothy Ray. Detective Booth, were you able to review that missing persons report that Timothy Ray was a suspect of?
Yes, ma'am, I was.
If I were to show you that report today, would you recognize it?
I would.
Directing court and counsel to what has been previously marked and admitted as Exhibit 7 and to what has been previously marked as Exhibit 29. Detective Booth, what is Exhibit 7?
Exhibit 7 is the missing persons report that Jessica Ray filed.
What is Exhibit 29?
Exhibit 29 is a photograph of Nathan Ray that was attached to the missing persons report.
Is Exhibit 29 a fair and accurate depiction of Nathan Ray?
It is.
Has Exhibit 29 been changed or altered in any way?
It has not.
The state offers Exhibit 29 into evidence.
Is there any objection?
Objection, Your Honor.
Basis?
Yeah, this photograph is substantially more prejudicial than it is probative. There is nothing in this photo that Detective Booth himself cannot testify to as regards to identifying Nathan Ray as the victim in this case, and therefore is only being presented by the prosecution in order to inflame the passions of the jury and to flash a photo of Nathan Ray's face up to incite their emotions.
Okay, Ms. Wareman, what's the relevance?
Your Honor, this photo of Nathan Ray is relevant for many different reasons. For one, it's a photograph of our victim. As the prosecution, the jury has the right to see our victim, to see his face, to know why we are here today and who we are here today for. Further, Your Honor, this photograph was attached to the missing persons report, as Detective Booth has already told us. This missing persons report has already been stipulated to and admitted as Exhibit 7. Further, this missing persons report was a public record, Your Honor.
How is it relevant to the ultimate issue in the case?
Your Honor, this photo was used to identify Nathan's body when it was buried in Brandywine State Park. And Your Honor, this photograph is of the victim, making it highly relevant.
All right, I'm going to allow it into evidence. You have an exception, Mr. Hudak. You may proceed.
Permission to publish, Your Honor.
Permission granted.
Detective Booth, how old was Nathan Ray when this missing persons report was filed?
He was just 6 years old.
Did you ever find Nathan Ray?
We did.
What state was he in when you found him?
He was in West Carolina and Skelton.
Oh, how did you find Nathan Ray?
We found him in Brandywine State Park.
Did you take pictures of his body when you found it?
Yes.
Directing court and counsel to what has been previously marked as Exhibit 21 on page 98 of the record. Detective Booth, what is Exhibit 21?
Exhibit 21 is a photograph that we took of Nathan Ray after we found him.
Is Exhibit 21 a fair and accurate depiction of how you found Nathan's body?
Yes, ma'am, it is.
Has Exhibit 21 been changed or altered in any way?
It is not.
The state offers Exhibit 21 into evidence.
Is there any objection?
Yes, Your Honor. The probative value is not, or the unfair prejudice substantially outweighs its probative value in this case for whatever purposes the prosecution claims. They already have Detective Booth's testimony. They already have the autopsy previously admitted into evidence. Now they have the photo of Nathan Ray's face for identification. This is now not only unfairly prejudicial, but now approaching or surpassing needlessly cumulative.
Just one photograph, Ms. Wareman?
Yes, Your Honor, just one photograph, therefore it is not cumulative, but I will address the other issues if you like.
Please, briefly.
Your Honor, this is highly relevant in today's case. This is a murder trial where the defendant admits to killing his son, Nathan. It is not prejudicial, Your Honor. There is no blood or gore. It is a photograph of how Detective Booth found Nathan's body wrapped in a trash bag in Brandywine State Park. Your Honor, again, this is highly relevant in this murder case to see how he disposed of the body. Again, Your Honor, the defense has put the defendant's state of mind at issue. This photo of how he disposed of the body goes to show that he had understanding of what he was doing, enough to dispose of the body.
All right. After hearing arguments, I do believe it's relevant, and I'm not inclined to follow the 403 argument in this particular case, so I'm going to allow it in. Thank you, counsels.
Yes, Your Honor. Detective Booth, what are we looking at in this photograph once it's published?
You can see here the body of Nathan Ray tossed in a shallow grave, wrapped in a trash bag with his shoes sticking out.
Where did you find Nathan's body?
In the woods in Brandywine State Park.
Now, Detective Booth, I want to talk to you more about your investigation into the defendant. How did you become involved with that investigation?
So like I said, Jessica Ray, Nathan's mother, filed the missing persons report. And on October 19th, 2018, I received a phone call that the suspect, Timothy Ray, had been stopped at a DUI checkpoint. So I went to the scene.
What did you learn when you arrived at that DUI checkpoint?
I learned that Timothy would not give the responding officer his license and registration when asked. And once he was out of the car and the officer began trying to handle him, he started acting strange.
What else did you see at that DUI checkpoint?
So in the backseat of the defendant's car, there was 2-gallon jugs of bleach, a shovel, and a large box of large black trash bags.
Was the defendant's car ever searched?
Yes, ma'am. After we got a warrant, we conducted a search of the car.
Did you take photographs of the defendant's car when it was searched?
We did.
If I were to show you one of those photos today, would you recognize it?
I would.
Directing court and counsel to what has been previously marked as Exhibit 23 on page 100 of the record. Detective Booth, what is Exhibit 23?
Exhibit 23 is a photograph we took of the backseat of the defendant's car.
Is Exhibit 23 a fair and accurate depiction of how the defendant's car looked at that DUI checkpoint?
It is.
Has Exhibit 23 been changed or altered in any way?
It has not.
The state offers Exhibit 23 into evidence.
Any objection?
No objection, Your Honor.
Okay, without objection, it is in evidence.
Detective
publish.
Booth, thank you, Your Honor. Detective Booth, what are we looking at in this photo?
So you can see here the 2-gallon jugs of bleach, the large black trash bags, and the shovel beside a booster seat and some kids' toys.
Detective Booth, what else did you do at that DUI checkpoint?
I told the defendant that he was under arrest and we were taking him to the station to ask him some questions.
What did the defendant do when you arrested him?
Not much. He just looked at me and said he understood and he wanted to tell me everything.
Now, when you brought the defendant to the police station for questioning, what is the first thing that you did?
Well, before we start our interviews of suspects, we get them to sign a Miranda waiver. So Timothy Ray would sign a Miranda waiver.
Directing court and counsel to what has been previously marked and admitted as Exhibit 4 on page 45 of the record. Detective Booth, did the defendant ever indicate to you that he understood what was going on at the police station?
Oh, yeah. He told me several times that he understood, and then he signed the Miranda waiver that said he understood. So I based my thoughts on that.
Now, Detective Booth, I want to talk to you about your interview with the defendant. What did you learn in this interview?
First, I learned that he strangled his son to death with his own belt. And then after he brutally murdered his son, he put him in a black trash bag and tossed him in a hole in Brandywine State Park.
Detective Booth, you just told us that the defendant confessed to strangling his son with a belt. Were you ever able to locate that belt?
We were.
Did you take photographs of the belt when you found it?
Yes, ma'am.
If I were to show you one of these photos today, would you recognize it?
I would.
Directing court and counsel to what has been previously marked as Exhibit 27 on page 104 of the record. Detective Booth, what is Exhibit 27?
Exhibit 27 is the belt that Timothy Ray used to strangle Nathan Ray.
Is Exhibit 27 a fair and accurate depiction of the belt that you found?
It is.
Has Exhibit 27 been changed or altered in any way?
It has not.
The state offers Exhibit 27 into evidence.
Any objection?
No objection, Your Honor.
Without objection, it is in evidence, and you may publish when you're ready.
Detective Booth, what are we looking at in this photograph?
This is where we found the defendant's belt in Nathan Ray's bedroom.
Where did the defendant tell you that he strangled his son to death with this belt?
In Nathan's bedroom at his house.
Now, Detective Booth, I know you said earlier that you found Nathan's body in Brandywine State Park, but did you ever find any other evidence indicating that the defendant was planning on disposing of his son's body?
We did. After getting a warrant to search the defendant's cell phone, we found a collection of Google searches.
Directing court and counsel to what has been previously marked and admitted as Exhibit 10 on page 57 of the record. When this is published, Detective Booth, would you tell us what the defendant searched on his phone?
Yeah, he searched for countries that don't extradite for murder charges, how to get rid of a body, and will bleach destroy a body.
Detective Booth, remind us, what all did you find in the defendant's car?
We found large black trash bags, a shovel, and 2-gallon jugs of bleach.
Now, Detective Booth, moving on in your investigation, was an autopsy ever performed on Nathan's body?
It was.
Were you present during this autopsy?
I was not, but I reviewed the autopsy and medical examiner's report during my investigation.
Directing court and counsel to what has been previously marked and admitted as Exhibit 6 on page 53 of the record. Detective Booth, what is Exhibit 6?
Exhibit 6 is the autopsy report of Nathan Ray.
What does the autopsy report say caused Nathan's death?
Asphyxiation.
What does that mean?
That just means that somebody had their oxygen supply cut off until they were killed or passed away.
Were there any other injuries on Nathan's body?
There were. He had bruises on his body, specifically on his neck. He had bruises about 1.5 inches or 2 inches wide.
Was the autopsy report consistent with what the defendant told you in your interview with him?
Absolutely. Given that he died from asphyxiation, it shows that Timothy Ray did in fact strangle his son to death, and the bruises on the neck were about the same size as the belt.
Nothing further.
Cross-examination.
Yes, Your Honor.
Okay.
Detective Booth, you were lead detective on this case.
Yes, sir.
You decided how the investigation was conducted.
That's right.
You decided what suspects to interview.
I did.
Timothy Ray was your only suspect in this investigation.
Yeah, it got narrowed down pretty quickly when he confessed to strangling his son.
You knew Timothy Ray before this investigation.
I met him a couple times a couple months before.
Both your kids play on the same soccer team.
That's right. They did.
While attending your kids' soccer events, you've had strange interactions with Timothy before.
I guess you could say that.
He acted socially awkward.
Yeah,
It was hard for him to hold a conversation.
that's what it seemed like to me.
He seemed uncomfortable.
I mean, he was just kind of awkward.
He looked generally unkept.
Yeah, I guess.
He had a scraggly beard and appeared dirty.
I don't know if he had a beard, but he didn't look very well kept.
Timothy Ray didn't fit in with the other parents.
I can't speak for everybody, but I thought he was kind of awkward.
Detective Booth, I would like to talk to you about your training. Have you received any specific mental health training?
I got some in the police academy when I went.
But you don't remember any of that training?
Honestly, no.
You can't name any of the psychiatric signs of schizophrenia?
No, I'll leave that to the doctors. I just conduct homicide investigations like the one the defendant.
During your interview with Timothy Ray, he was not acting strange.
I mean, it's hard to say strange in a homicide interview. I mean, he told me he strangled his son to death, and I thought that was pretty crazy.
He asked you if you were at the CIA.
Yeah, he did ask me that a couple times.
He referred to quote unquote they.
Yep.
You didn't ask him to clarify who he was talking about.
I didn't see it was necessary. I mean, he had already confessed to strangling his son to death with a belt and burying him in the woods.
Timothy Ray said he didn't mean to kill his son, correct?
I mean, I don't think that's a very uncommon excuse from a murderer.
But he did say that.
Yeah, he said it.
You notified Jessica Ray, Timothy's wife, about this incident?
Yeah, I had to. She was the one that made the missing persons report.
To the best of your knowledge, you were the first person to notify Jessica Ray of this incident.
To the best of my knowledge, yeah.
She appeared shocked,
I mean, I couldn't see her. I was just talking to her on the phone.
but she started crying uncontrollably.
Yeah, she was crying. I mean, I had to tell her that her ex-husband had murdered her son.
She told you that I should have never left Nathan alone with him when he was acting strange. I knew he was going crazy.
Objection, hearsay.
Response?
This falls under the exception under excited utterance under Rule 8032.
Ms. Werriman?
Your Honor, Detective Booth has just told us that he could not see Jessica Ray and that he would not have the knowledge, so it would be mere speculation if she was excited at this time.
Can we agree that somebody who just found out that their child died might be excited at that time?
If that is what your honor feels, you are the gatekeeper.
Fair enough. I will overrule the objection and allow the question.
Detective Booth, Jessica Ray told you, I knew I should have never left Nathan alone with him when he was acting strange. I knew he was going crazy.
That's what she said, yeah.
Detective Booth, Skelton Police Department has specific directives for collecting evidence.
They do.
These directives tell you to preserve evidence.
To preserve relevant evidence or evidence that I need for my investigation, yes.
This interview was video recorded.
It was, yeah.
But you did not retain a copy of that interview?
Well, under the directives, I'm not required to keep every copy. I had a transcript of the interview and I thought that was sufficient.
You don't believe that in the case where an individual might be suffering from a mental illness to keep the video?
I mean, like you said, I'm not a psychiatrist. I'm just a homicide detective.
If those signs were present, they would show up in the video, correct?
Maybe.
No further questions.
Redirect?
Yes, your honor. Detective Booth, why did you not keep the video recording of this interview?
Because I had the transcript, and on the transcript, the defendant admitted to me several times that he strangled his son to death with his belt and buried his body in the woods.
Nothing further.
Okay, you may step down, detective. Thank you. And you may call your next witness, state.
Your Honor, at this time, the state calls Dr. Mac LaGreca.
Dr. LaGreca, you may proceed when you are ready, Ms. Messmore.
Would you introduce yourself?
My name is Dr. Mac LaGreca.
Dr. LaGreca, what do you do for a living?
I'm a forensic psychiatrist
How long have you been a forensic psychiatrist?
for 26 years.
Now, Dr. LaGreca, where did you go to school to become a forensic psychiatrist?
I got my medical degree from the University of Pennsylvania, then completed my residency, then fellowship in psychiatry.
Now, doctor, in your 26 years of experience, what kind of cases have you handled?
I've handled a diverse population of patients and cases, treated a wide variety of mental illnesses, including schizophrenia.
Now, doctor, have you ever testified as an expert before?
Yes, I have 7 times.
Have you ever testified regarding schizophrenia?
Yes, 3 of those times were regarding schizophrenia.
Your Honor, at this time, the state offers Dr. Mac LaGreca as an expert in the field of forensic psychiatry.
Any objection?
Yes, Your Honor. Defense objects under 702, and we request to voir dire on the issue.
Okay, you may voir dire.
Thank you. Dr. LaGreca, the DSM-5 is the authoritative source for your opinion.
Yes, it's the manual psychiatrist
Objection,
used.
Your Honor.
Basis?
Your Honor, voir dire is strictly for purposes of qualification of this expert, not for the materials that he relied on in forming his opinion.
I agree. I'm going to give her a little bit of leeway, all right? So let me just
Yes, Your Honor.
hear where we're going, okay? You may continue, Ms. Allen.
Yes, Your Honor. The DSM-5 is the authoritative source for your opinion.
For my expert medical opinion, I rely on the DSM-5 criteria, yes.
It's the principal method you relied on.
Your Honor, renewing objection.
I understand. Sorry. I understand the objection. I'm going to give her let me just see where she's going. I'm going to give her a little bit of leeway here. I just want to see where we're going, okay?
Yes, Your Honor.
You may continue, Ms. Allen.
The DSM-5 is the principal method you relied on to come to your conclusion.
I relied on all of the facts of the case as I have reviewed them and then used the DSM-5 criteria to diagnose psychiatric illnesses to then make my diagnosis an expert medical opinion.
Now, there are 4 factors in determining if someone is malingering based on the DSM-5.
Yes,
Those 4 factors are listed out in the DSM-5.
All right, I'm going to sua sponte, just ask, outside the presence of the jury, Ms. Allen, where do you intend to go with this voir dire?
Yes, Your Honor. If I may further test or question Dr. LaGreca, it is to go into his applying his methods, whether reliably or not. We will, if I may proffer.
Please proffer.
If allowed to further, we will hear that Dr. LaGreca also considered a fifth element, evading criminal prosecution. And we'll learn that it's not memorialized as a factor in the DSM-5, which goes to show that Dr. LaGreca did not reliably apply the principles and methods to the facts of the case.
Ms. Messmore, you want to respond?
Your Honor, this line of questioning is for cross-examination and has nothing to do with whether or not this doctor is qualified as an expert in the field of forensic psychiatry.
Okay, I'm going to agree at this time with Ms. Messmore that I think that this line of questioning is probably better off on cross-exam and allow you to question the witness at that time regarding this area. And if there's no other objection, I will qualify this witness and they can give their opinion.
Yes, Your Honor. Other than that, we do not have an objection.
All right, you may continue then, Ms. Messmore.
Yes, Your Honor. Now, Dr. LaGreca, were you able to form an opinion in today's case?
Yes, I was.
And is your opinion based on reasonable or sufficient facts and data?
Yes.
Is your opinion today based on reliable principles and methods?
Yes.
Doctor, in reaching your opinion today, were you able to apply those reasonable principles and methods to the facts of this case?
Yes, I was.
And doctor, is your opinion today based to a reasonable degree of medical certainty?
Absolutely.
Dr. LaGreca, in forming your opinion today, what all did you review?
I reviewed all of the materials in the case file, including Dr. Riley's reports, the various interviews with the defendant, Detective Booth, Officer Wentz. I also reviewed the defendant's, past medical history off his medical records, and then I also consulted the DSM-5 criteria for schizophrenia.
So, doctor, after reviewing all of that, what is your opinion in today's case?
I believe that the defendant was not suffering from schizophrenia and that his actions post-arrest was consistent with malingering.
So, doctor, you just used the word malingering. What does that mean?
So malingering is essentially a technical term that means that an individual is creating a set of symptoms, essentially faking a set of symptoms for secondary gain. And in this case, it would be for the creation of a legal defense.
So, doctor, after reviewing all of the materials in today's case, what indicated to you that the defendant was malingering or faking his symptoms rather than suffering from schizophrenia?
So there are a wide variety of instances that led me to make the diagnosis or make the technical term of malingering. The first being, the fact that he never reported his symptoms until he met with Dr. Riley when he was sitting in jail and, facing the consequences of his actions. And that's when all of the symptoms were first reported, never before to any other physician.
So, doctor, you said that was the first indication. What was the second indication in your review of today's case?
So, also I took a look at the interaction between the officer and the defendant at the DUI checkpoint. The defendant was acting, somewhat normally initially, and then as soon as he realized that the officer needed his license, registration, things like that, he, then started asking about the CIA and things like that. So it's not a consistent display of schizophrenic symptoms. It's the fact that he did so at a later point in time indicates that could be malingering.
So, doctor, you pointed to two instances that made you believe and come to the conclusion that this defendant is not suffering from schizophrenia and is rather faking his symptoms. Were there any other indications?
Yeah, I also reviewed the fact that he was basically interacting with Detective Blake, or Detective Booth rather, initially, and he was acting really strange, as Detective Booth noted. However, at the end of the interview, what was striking to me is that he referred to the officer by his first name. He said something along the lines of, Blake, you have to help me. You said you would help me. And so this pointed to me that, initially he acted strange, but as soon as the defendant realized that his sort of faking of his symptoms wasn't really being bought by the officer, he started to appeal in a different way to the officer.
So, doctor, in your experience as a forensic psychiatrist, how many people suffer from schizophrenia?
It's around 0.1 to 1% of the population.
What about this phenomenon that you call malingering or faking symptoms for external gain?
Malingering would be fairly more common. Around 19% of the people who were interviewed in the context of a criminal case are malingering, found to be malingering.
So, doctor, in reaching your conclusion today, were you able to review the defendant's medical history?
Yes, I was.
If I was to publish a demonstrative summarizing the defendant's medical history, would that assist you in your testimony today?
Yes.
Your Honor, at this time, the state would like to publish a demonstrative via share screen to assist the expert in testifying.
Ms. Allen, any objection?
No objections, Your Honor.
You may, Counselor.
So, Dr. LaGreca, in your review of today's case, when was the first time that the defendant saw a medical professional?
He saw Dr. Riley at Walter Reed in 2010.
At this visit with Dr. Riley, what kind of symptoms did the defendant report?
He reported symptoms of anxiety, depression, difficulty sleeping, high levels of stress, and he denied symptoms of hallucinations, delusions, suicidal thoughts, basically anything that would point towards a schizophrenic spectrum disorder.
Based on all of the symptoms that the defendant denied in 2010, what was Dr. Riley's diagnosis?
It was generalized anxiety disorder as per Dr. Riley.
Now, doctor, when was the next time that the defendant saw a medical professional?
He saw his primary care doctor, Dr. Di Giuseppe, in 2011.
What kind of symptoms did he report at this visit?
The similar symptoms as before were reported, namely anxiety, depression, trouble sleeping, and he also denied the same symptoms: hearing voices, hallucinations, delusions, suicidal ideation.
So, doctor, at this visit, the defendant again denied hearing voices and hallucinations and delusions?
Yes.
And was Dr. Di Giuseppe able to come to a diagnosis at this visit?
No.
Doctor, in your review of today's case, when was the next time that the defendant saw his primary care physician?
I believe it was 2014.
So at this visit with Dr. Di Giuseppe in 2014, what symptoms did he report?
The same symptoms: anxiety, depression, difficulty sleeping, and denied the same symptoms: hallucinations, delusions, suicidal thoughts.
Dr. Riley, up until 2014, had the defendant ever claimed to have hallucinations or hear voices?
No.
What was Dr. Di Giuseppe's diagnosis in 2014?
She did not make one.
Now, when was the next time that the defendant saw Dr. Di Giuseppe?
I think 2016.
And at this visit, what kind of symptoms did the defendant report?
The same symptoms: anxiety, depression, high levels of stress, difficulty sleeping, and he denied, once again, hallucinations, delusions, suicidal thoughts.
At this visit, did Dr. Di Giuseppe diagnose the defendant with anything?
No.
So, Dr. Riley, when was the next time that the defendant saw any medical professional?
It would be in 2019, September of 2019, where he saw Dr. Riley in jail.
While sitting with Dr. Riley in jail, what kind of symptoms did the defendant report?
So at this visit, he reported, a vastly different set of symptoms. He reported hallucinations, both auditory and visual, significant paranoid delusions, emotional instability, aggressiveness, voices, basically a whole different set of symptoms. that he had previously denied.
So, doctor, the defendant has never admitted these symptoms before?
This would be the first time.
Now, did the defendant ever see another physician?
Yeah, he saw Dr. Narasimhan in jail as well, and I believe that was in October of 2019.
So just a month after meeting with his expert, what kind of symptoms did the defendant report?
To this doctor, he reported anxiety, depression, and stress, but none of the other symptoms that he had reported to Dr. Ryrie, such as hallucinations or delusions or negative thoughts and things like that.
And at this visit, did this doctor reach a diagnosis?
No.
Dr. LaGreca, in your experience, in your professional opinion, is there anything that could explain why the defendant would report these symptoms in September of 2019 and not October?
Yes, he was malingering.
What happened in October of 2018 to create this phenomenon of malingering?
In October of 2018, he killed his son and he was caught.
Okay, doctor, in your professional opinion, is the defendant suffering from schizophrenia?
No.
No further questions from this witness, Your Honor.
Okay, thank you very much, Counselor. Cross-exam.
Yes, Your Honor. Dr. LaGreca, you're being paid for your work today.
Yes, as is any expert witness.
You're getting your hourly rate of $500 per hour.
Yes.
You're also being paid a testimony rate.
Yes, that is customary.
That's a flat fee of $1,750 per day.
Yes.
And you've been an expert witness before.
Yes.
You've testified in 7 prior cases.
Yes.
6 of those times you were retained by the state.
Yes.
Dr. LaGreca, your discipline teaches that family history of mental illness can increase the risk of a mental illness in a patient.
Yes. Anxiety
disorder experienced as a young man can worsen to a more serious mental illness.
That's not necessarily true. I mean, any mental illness increases the chance of another mental illness.
Is it your testimony today that anxiety disorder experienced as a young man cannot worsen to a more serious mental illness?
No, I never said that. I said any mental illness can increase the chance of later developing another mental illness.
It could experience it could become schizophrenia.
Is that any mental illness? Yes, it can.
Now, anxiety disorder is very common in America.
Okay, yes, I believe so.
1 in 5 Americans suffer from an anxiety disorder?
If you say so.
Dr. LaGreca, doesn't your discipline teach you that 1 in 5 Americans suffer from an anxiety disorder?
It's fairly common. I mean, I don't have the numbers off the top of my head.
Your discipline teaches you that childhood trauma can make a person more likely to develop a severe mental illness.
Yes.
A mental illness not treated could worsen to a more severe mental illness.
Yes.
It's your opinion that Mr. Ray did not show symptoms consistent with schizophrenia.
Yes.
I want to talk about one of those, the hallucinations, specifically auditory. Now, Mr. Ray described hearing a voice telling him things.
Yes, that was reported by him.
He referred to these voices as they.
What instance are you referring to?
When he spoke with Detective Booth, he referred to they.
Yes.
Now, you cannot definitively categorize what Mr. Ray experienced was in fact voices.
Can you rephrase the question? I'm not understanding.
You cannot definitively state that what Mr. Ray experienced was in fact voices.
Yes, I cannot state that.
and you cannot definitively categorize what Mr. Ray experienced was thoughts.
What he was experiencing was thoughts? Is that what you asked?
Correct.
I have no, I mean, he could be saying something, as I mentioned, I believe he was malingering, so I believe he was faking whatever he was saying.
However, Dr. LaGreca, you cannot categorize definitively what Mr. Ray experienced was in fact just thoughts.
I have no idea what was going on in his head. I can only go by what he was reporting.
All right, Dr. LaGreca, you believe Mr. Ray was malingering.
Yes.
You considered all 4 factors of the DSM-5?
What are you referring to when you say all 4 factors?
The DSM-5 lists 4 factors for malingering.
What 4 factors? I don't believe the DSM-5 includes malingering and lists that. It may state that, but I'm not aware of any 4 factors.
Drawing the court and counsel's attention to Exhibit 17B, which is found on page 94 of the court report. Dr. LaGreca, you see Exhibit 17B?
No, I don't see it. Where is it?
Dr. LaGreca, do you have a copy of the file with you?
I would have to pull it up.
Your Honor, for purposes of this, I would be more than happy to drop a copy of Exhibit 17B into the chat.
If you and defense attorney want to agree to that, that's fine. I just want to try to move it along if we can.
Yes, Your Honor.
Dr. LaGreca, there is a copy of Exhibit 17B in the chat.
Okay.
Dr. LaGreca, do you have the DSM-5 definition
Yeah, I see
as well
it.
as the factors?
Yeah, I see it. Yes.
You would agree with me that is a fair and accurate representation of what's laid out in the DSM-5 for malingering?
Yes.
Now, you'd agree with me that there are factors that are bulleted in the DSM-5.
Yes.
There are 4 factors.
Mhm.
None of those factors state evading criminal prosecution.
It doesn't say so specifically, no.
Now, you'd agree with me, you cannot testify to evading criminal prosecution being peer-reviewed or published for malingering.
So that would fall under secondary gain, which is the definition of malingering.
However,
So
Dr. LaGreca, I'm bringing you back to my question. You cannot testify to any peer-reviewed publications articulating evading criminal prosecution as a factor for malingering.
in my personal experience, I've experienced that, and that's widely known. Malingering is for secondary gain, and that could be anything.
Now, Dr. LaGreca, you relied on evidence that was given to you today.
I reviewed all of the facts of the case.
You did not conduct any personal interviews.
No.
You did not interview Detective Booth.
I did.
Dr. LaGreca, is it your testimony you did interview Detective Booth?
I don't believe so, actually.
You did not interview Detective Booth.
No.
Detective Booth was familiar with Mr. Ray prior to this case.
I'm aware.
You did not interview Jessica Ray.
No.
Miss Ray was married to Mr. Ray for 6 years.
Okay. Yes, I'm aware.
You did not interview Abre.
No.
That was Mr. Ray's father.
Yes.
You did not interview or talk to Dr. Riley.
I did not need to. I had all of his medical notes and interview notes in front of me.
You were given what was given to you by state in the exhibit list, correct?
I was given all of the information in the case file, which I reviewed.
Now, you did not interview Dr. DiGiuseppe,
No, I had all of her notes.
and Dr. DiGiuseppe was Mr. Ray's primary care physician.
Yeah.
You did not interview Dr. Narasimhan.
Once again, I did not need to. I had all of the notes and medical records from the case file.
You agree with me that you did not interview Dr. Narasimhan.
As I said, no, I did not. I had all of the information.
Dr. Narasimhan prescribed Mr. Ray's current medication.
Yes.
I have nothing further at this time.
Redirect.
Yes, Your Honor.
Your
Dr.
proceed.
LaGreca, opposing counsel spoke a lot to you about Exhibit 17B, which is the DSM entry for malingering. If I was to show you a copy of that, would you recognize it?
Yeah.
Citing court and counsel to Exhibit 17B, located on page 94 of the record. Dr. LaGreca, what is Exhibit 17B?
It's a DSM-5 definition for malingering.
Is Exhibit 17B a fair and accurate representation of the DSM entry for malingering?
Yes.
Has Exhibit 17B been edited or altered in any way?
No.
Your Honor, at this time, the state offers Exhibit 17B into evidence.
Any objection, Ms. Allen?
No objections.
Without objection, it is in evidence.
Your Honor, permission to publish Exhibit 17B.
Permission granted.
Dr. LaGreca, turning your attention to that first paragraph or definition of malingering, could you read that aloud to the jury?
Malingering is the stimulation or simulation of a disease characterized by the intentional production of false or grossly exaggerated physical or psychological symptoms motivated by external incentives. Examples of such incentives include avoiding military duty, avoiding work, obtaining financial compensation, evading criminal prosecution, or obtaining drugs.
So, Dr. LaGreca, in forming your opinion today, did the fact that the defendant was facing criminal prosecution impact your opinion?
Absolutely.
No further questions, Your Honor. May this witness be excused?
The witness may be excused. You may call your next witness. State.
Your Honor, at this time, the state rests.
Okay. Do we have any motions?
Yes, Your Honor.
You may proceed.
Your Honor, defense motions for a judgment of acquittal under Federal Rules of Criminal Procedure 29A due to the prosecution's failure to bring forth evidence sufficient enough to sustain a conviction. Even when viewing the evidence in light most favorable to the non-moving party, the prosecution has failed to put forth sufficient facts so that a reasonable jury or trier of fact could find for them in this case of action, first-degree murder, beyond a reasonable doubt. Specifically, the prosecution has failed to prove Mr. Ray's killed with malice aforethought at the time of the murder. No evidence has been brought forth to show beyond a reasonable doubt Mr. Ray's intent or mens rea at the time of the murder. And because of that, we request Your Honor grant a judgment of acquittal for the defendant. Thank you.
Thank you, Ms. Allen. Ms. Messmore.
Yes, Your Honor. When considering whether or not the defendant acted with the requisite mental state, which is in this case malice aforethought, premeditation can be considered. Your Honor, premeditation can happen in an instant. The decision to kill can be made in a second. Your Honor, we presented evidence today that this defendant wrapped his belt around his son's neck and strangled him to death. That decision in itself is premeditation. Your Honor, sufficient facts and evidence has been presented to this jury for a reasonable juror to conclude that this defendant not only killed Nathan Ray, but did so with malice aforethought. And as such, the defense's motion is due to be denied.
Okay, I believe there's a question of fact presented to the jury as to whether the requisite intent was in fact shown. So we will continue. The motion will be denied and we will take a break. Okay, it's 5:33 right now. How about 5:43? Is 10 minutes long enough for all of you?
Yes, Your Honor.
Yes, Your Honor.
You're back at 5:43.
Yes, Your Honor.
Okay. I just want to make sure that our jurors are back before we begin. Clearly, we have all the advocates. Could you all, the jurors, just, all right, great.
Your Honor, before we begin, may we get a brief time check for the record?
Yeah, that would be great, actually.
Our timekeeper will get on and let us know.
Your Honor, the prosecution has 24 minutes and 24 seconds remaining.
Okay. Defendants?
Your Honor, the defense has 36 minutes and 12 seconds remaining.
Okay. Everybody says, agree with that? No issues? Okay.
Yes, Your Honor.
I just want to check, Juror Gershman, you're here? Great. And Juror Ho, you're here? Fantastic. All right, thank you. So we have our jurors present, and we can begin defense's case. Whenever you are ready, you may begin, counselors.
Thank you, Your Honor. Defense calls Officer Wentz to the stand. Will you please introduce yourself?
Yes, my name is Officer Wentz.
Officer Wentz, how are you involved in today's case?
I was the first officer to come into contact with the defendant in this case at a sobriety checkpoint.
Now, before we talk about that sobriety checkpoint, let's talk a little bit more about you. How long have you been an officer?
I've been with Skelton PD for the last 2 years.
What responsibilities do you have as an officer for Skelton PD?
As of right now, my main duties involve traffic stops, sobriety checkpoints, and other general police work.
What training did you complete to become an officer?
After I did my undergraduate degree, I did go to the police academy, as all officers do, in addition to completing some crisis intervention training while I was there.
What is a crisis intervention training?
Crisis intervention training is a program that has been developed to help officers identify and be able to handle when we are approaching situations in which we might be dealing with a suspect with mental health conditions.
Now, you said you met with Mr. Ray at a sobriety checkpoint. What day was this?
This would have been on October 19th of 2018.
When did you come into contact with Mr. Ray?
I was working that checkpoint that evening, and he drove up to the checkpoint where I came into contact with him that evening. I'm unsure of actual time.
Please describe what you see when Mr. Ray approaches the sobriety checkpoint.
When I approached his vehicle to ask for his license and registration, as I do all vehicles that pull into the checkpoint, I noticed right away that he was acting very strange.
What do you mean strange?
Well, first, when I approached the car, he had this awful body odor, in addition to stains on his shirt and just acting very defiant and squirrely.
After evaluating his appearance, what did you do?
After I evaluated his appearance, I did at that point ask for his license and registration so as to run his vehicle for any suspicious activity of that criminal activity was afoot.
Did Mr. Ray give you his license and registration?
After hesitation, yes. He originally tried to tell me that he didn't have it, even though it was right next to him.
Officer Wentz, at this point, were there any signs of intoxication?
No, and that was the strange thing, is he didn't appear to me to be intoxicated. He wasn't slurring his speech or anything like that. But as I said, he was acting strange, like nothing I'd never seen before.
When you have his license and registration, what do you do next?
Well, I was originally going to go run it, but on my way back, I happened to notice some disturbing items in the back seat. And after his weird responses and craziness interaction thus far, I decided for my safety, as well as my partner's safety, and to ensure he didn't flee, that it was best if my partner ran that information.
What happened when you returned to Mr. Ray's vehicle?
When I returned, he started asking these absolutely crazy questions about if I was with the CIA, saying he could hear the CIA sirens coming for him, and that he knew the CIA had been watching him because they thought he was a terrorist.
Why did this stand out to you?
I've never seen anything like that, even in simulations and training, and there was definitely no sirens that I could hear.
Prior to him saying you were CIA, had you identified yourself?
Yes, a minute earlier, we had been having a discussion of the fact that this was a typical sobriety checkpoint, that I was an officer with Skeleton PD, just wanting to make sure everything was okay.
How did you respond when Mr. Ray called you or accused you of being a CIA?
At this point, I had attempted to, again, show him my credentials and gently remind him that I am an officer with Skeleton PD, just trying to do a traffic routine stop, not a CIA agent, as I had told him only moments before.
After you identified this, what happened?
At this point, I decided it would be in the best interest for me, as well as my other officer's safety, to ask the defendant to get out of the car at this time.
Did he comply?
Yes, he did.
What was Mr. Ray's demeanor as he stepped out of the vehicle?
He was moving very slowly, and he had this very strange blank stare on his face, wouldn't make any eye contact with me at all, and he just stood there and talked in a monotone voice.
Are you aware if he was talking to you?
I honestly don't believe he was. He looked like he was either talking to himself or talking to no one at all.
How did you react to Mr. Ray?
Well, I tried to ask for clarification to see if he was trying to ask me a question, but he didn't answer. He kind of looked up at me like he hadn't even noticed I was there, like we hadn't been having this interaction for at least the last 10 minutes. And then he started to do a jumping jack.
Do you know why he was doing jumping jacks?
I have no idea. I told him to stand still, but it seemed like he didn't even hear me, which is why I decided to pull out my gun and yell at him to stop moving.
Did Mr. Ray stop moving?
No, not at that time.
What did you do?
I had to fight really hard with him to get his arms down, which is when eventually I was, and then I was able to cuff him and sit him down on the curb a few feet away from my patrol vehicle.
Officer Woods, what if any significant findings did your partner come back with from the search of Mr. Ray's license and registration?
It was at this point that we learned of the missing report filed the day before. Once I had this information, I went ahead and called Detective Booth, and we later brought Mr. Ray to the police station.
I have no further questions at this time.
Cross-examine.
Yes, Your Honor. Officer Wentz, you just told us that you're a patrol officer.
Yes, I am.
With the Skeleton Police Department.
Yes, I am.
Or you've been working for what, 4 years now?
2 years, actually.
Oh, 2 years. I'm sorry. Now, in your 2 years of experience, you've been working as a patrol officer.
Yes.
Before that, you had to go to the police academy.
Yes, as do all officers.
Or you took classes on how to handle weapons.
I did.
How to handle suspects.
Yes.
And you just told us that you took a special class on mental health.
Yes, I did. It was a 40-hour class.
That's right. You spent about a week learning about different mental illnesses.
Yes, I did.
And how to identify suspects with potential mental illnesses.
Yes.
But Officer Wentz, you'd agree with me that you're not qualified to diagnose patients.
No, I'm not a doctor.
You're not qualified to treat patients.
No.
You're not qualified to specify what mental illness someone's suffering from.
No, not a specific illness, no.
Because like you said, you're not a doctor.
I'm not.
Which means you're not an expert in schizophrenia.
No, I'm not.
You're not an expert in malingering.
No, I'm not.
But as a cop, you do know that when people think they're in trouble, sometimes they might lie.
Sometimes, yes, but this was an instance of something I had never encountered before. This was absolutely crazy.
Now, officer, that wasn't my question. Sometimes people lie when they think they're in trouble.
Yes, generally.
They might lie about how fast they were driving.
Yes.
They might lie about how
Objection,
many.
Your Honor, relevance.
I'm sorry, the objection was to relevance. Overruled, cross.
Officer Wentz, sometimes people might lie about how many beers they've had.
Yes.
They might even lie and try to tell you that the drugs aren't theirs.
Yes.
So, Officer Wentz, I talked to you a bit about what happened at that DUI checkpoint. When you asked the defendant for his license, he told you that he didn't have his wallet.
Yes, he did.
But his wallet was sitting on his passenger seat.
Yes, I was able to see that from where I was standing.
After you told him that you could see his wallet, he gave you his license.
He did.
But you also asked him for his registration.
I did.
He told you that he didn't have that either.
Yes, he did tell me that.
But eventually he reached into his glove box and pulled that out for you.
Yes, he did.
Now, with his license and his registration, you decided to run his information.
I did, yes.
So you began to walk to your patrol car.
Yes,
That's when you shined your flashlight in his back seat.
I did.
That's when you saw the shovel,
Yes, there was a shovel.
the bleach,
There was also bleach, yes.
the trash bags.
Yes,
All of this was sitting on top of a booster seat
it was, yes.
next to some Legos.
Yes,
Now, Officer Wentz, at this point, you became worried that the defendant might try to run off.
yes, I was.
So you had your partner run his information.
I did, yes.
And you walked back up to his driver's side window.
I did.
Now, just so we're clear, up until this point, the defendant was able to speak in clear sentences.
Yes.
He was able to understand what you were asking him.
As far as I could tell, I can't tell if anyone can understand from my perspective.
But officer, the defendant was able to give you his license.
After some hesitation, yes.
And after some hesitation, he was able to give you his registration.
Yes.
Now, Officer Wentz, it was not until after this defendant gave you his license and his registration that he said anything about the CIA.
That is correct, yes. It was after I returned.
It was not until after the defendant had given you his license and his registration that he asked you for your CIA credentials.
Correct.
It was not until after you asked this defendant to get out of his vehicle that he began to do jumping jacks.
That is correct.
It was not until after this defendant gave you his license and his registration that he said anything about being a good father.
Yeah, we hadn't discussed anything like that previously.
And Officer Wentz, it was not until after this defendant had given you his personal information that he began to repeat, "I am a good father. I didn't mean it."
That is correct.
No further questions, Your Honor.
Redirect.
No redirect, Your Honor. I just asked Officer Wentz be excused.
Absolutely. And you may call your next witness.
Your Honor, defense calls Major Riley to the stand. Excuse me, Your Honor, is Major Riley pre-sworn?
Yes, you may begin whenever you're ready.
Thank you, Your Honor. Please introduce yourself.
My name is Major Shane J. Riley.
Major Riley, why are you here?
I was retained by defense counsel to review Mr. Ray's case and form an opinion regarding whether and to what extent Mr. Ray suffered from any mental disorder that would affect his ability to discern right from wrong.
Did you form an opinion for today?
Yes, I did.
Before we get to that opinion, what makes you qualified to discuss mental disorders?
I currently have a private practice called Riley Forensic Psychiatry, and I work extensively with patients with mental disorders.
What education led you to owning your own private practice?
After I received my degree in biology from the University of Notre Dame, I received my MD from the Uniformed Services University of the Health Sciences, also known as the USU, where I graduated 4th in my class.
What, if any, further education did you receive after medical school?
After graduating medical school, I completed a 4-year residency at the National Capital Consortium Psychiatry Residency Program at the Walter Reed National Military Medical Center. Following my residency, I completed a 1-year fellowship at Walter Reed in forensic psychiatry.
What did you do after completing your education?
I went into the Army. I served as a psychiatrist in the 2nd Infantry Division for a few years.
I want to take a moment and say thank you for your service, Major Riley.
You're welcome.
What did you do after serving?
I worked for Walter Reed for 9 years until I opened up my own private practice.
What did you do at Walter Reed?
First, I was a managing clinical psychiatrist in the psychiatric inpatient unit for 5 years, and then I became the deputy director of the Department of Behavioral Health for 4 years.
What, if any, publications do you have dealing with mental disorders?
I've written 15 peer-reviewed publications in the field of forensic psychiatry, 2 of which are specific to schizophrenia.
What certifications do you have?
Since 2001, I've been board certified by the American Board of Psychiatry and Neurology.
Major Riley, how many times have you testified in court?
I have testified, I've served as an expert witness 25 times, 18 of which were criminal cases.
Now, focusing on this case, what evidence did you use to help form your opinion?
The evidence I used, in addition to my background and clinical training, were all of the materials on the joint exhibit list, former treatment I had with Mr. Ray, a clinical interview with Mr. Ray, and additional interviews with Mr. Ray's wife, Mr. Ray's boss at Computerland, and Mr. Ray's father.
Was this sufficient facts and data to base your opinion on?
Yes.
What methods and principles did you use to come to your opinion?
I used the DSM-5 along with my background and clinical training to analyze the symptoms manifested by Mr. Ray during his lifetime.
Is this method reliable in your field of study?
Yes, I followed all of the accepted and reliable best practices within the field of psychiatry to come to my opinion.
Is your opinion based on a reasonable degree of medical certainty?
Yes, it is.
Your Honor, I move to admit Dr. Riley as an expert in the field of psychiatry and schizophrenia.
Ms. Wehrman, any objection?
No objections, Your Honor.
Okay, they are deemed an expert in that field and may give their opinion.
Major Riley, what is schizophrenia?
Schizophrenia is a neuropsychological disease, also known as a brain disorder.
How are you able to diagnose someone with this disorder?
The DSM-5 outlines the criteria needed to diagnose someone with schizophrenia.
What is the DSM-5's criteria for schizophrenia?
A person has to have 2 or more of the following symptoms for at least a 1-month period. They have to have delusions, hallucinations, disorganized speech, grossly disorganized or catatonic behavior, or have negative symptoms.
You mentioned negative symptoms. What are those?
Negative symptoms could be things like diminished emotional expression or depression. And these are symptoms that are associated with schizophrenia that could prevent a person from engaging in certain behaviors or could impair a person's ability to function.
You say that a person needs to have 2 or more of these symptoms. Why is that?
Schizophrenia as a disease manifests itself on a spectrum. Patients don't all have the same symptoms or severity of symptoms.
What are the causes of schizophrenia?
Although we don't know the precise cause of schizophrenia, we do know that there are certain contributing factors. These factors include family history, genetics, brain changes, chemical changes, substance use, complications during birth, and childhood trauma.
Now let's talk about each one of those individually. First, childhood trauma. How does that play a role?
Childhood trauma increases the risk for a person to develop schizophrenia. And this is because the events that happen during childhood have an immense impact on a person's developing brain. Studies have shown that the younger a patient is when they begin to display symptoms consistent with schizophrenia, the worse their prognosis is over their lifetime.
What childhood trauma did Timothy Ray experience?
Mr. Ray suffered childhood trauma based on my interview with his father, Abe Ray. Mr. Ray's mother was neglectful and abusive.
What examples did Abe Ray give about Timothy's childhood trauma?
Abe Ray informed me that Mr. Ray's mother would often refuse to feed Timothy and would also force him to take baths in ice cold water.
How long did Mr. Ray suffer from childhood trauma?
Mr. Ray suffered from childhood trauma from birth to the age of 3. And at the age of 3 is when his mother left their family.
What about genetics? How does genetics affect the potential for schizophrenia?
When there's a family history of schizophrenia or other mental illness, it places someone at an increased risk for developing that illness.
What did your research find regarding Timothy's mother's mental condition?
While Timothy Ray's mother was not formally diagnosed with a mental illness, she did show symptoms consistent with someone who has schizophrenia or at least an undiagnosed severe mental illness. This would increase the likelihood of Mr. Ray suffering from schizophrenia or some other severe mental illness in his lifetime.
How about related mental illness? How does related mental illness contribute to schizophrenia?
Many people with schizophrenia suffer from concomitant anxiety disorder, depression, or express suicidal ideation.
What did you notice from Mr. Ray regarding related mental illness?
Mr. Ray experienced all 3 of the related illnesses that I just noted. Even back while serving in the Army, Mr. Ray suffered anxiety disorder and depression when I saw him in 2010.
What symptoms did you observe in 2010?
I observed symptoms of anxiety and depression.
What were your findings in 2010?
I diagnosed Mr. Ray with generalized anxiety disorder.
What other symptoms were reported at that time?
Mr. Ray's commanding officer reported that he was suffering from hallucinations and suicidal ideations in 2010.
Why didn't you include these in your diagnosis?
I can only diagnose a patient based on the symptoms that I observe myself or symptoms expressed to me by the patient.
In your research of this case, why might Timothy Ray not express these symptoms to you?
In my later interview, Mr. Ray stated that he was afraid to tell anyone about his symptoms because he didn't want to be labeled crazy like his mom. And this fits in with the larger societal stigma against people with mental illness. So he had good reason not to disclose these symptoms.
Out of the 5 symptoms of schizophrenia, how many symptoms did Mr. Ray exhibit during your analysis?
Mr. Ray showed 3 of the 5 symptoms of schizophrenia as outlined by the DSM-5.
Which symptoms did he demonstrate?
He demonstrated delusions, hallucinations, and negative symptoms.
What delusions was Mr. Ray showing?
Mr. Ray showed signs of delusion through his paranoia regarding his wife and son in the years leading up to October 2018. He expressed these concerns when he met with Dr. DiGiuseppe in 2017, also on October 17th, 2018, and in his later interactions with Officer Wentz.
Now let's break that down. What paranoia did Timothy express to Dr. DiGiuseppe?
Timothy thought that Dr. DiGiuseppe was conspiring behind his back with his wife.
What were your conclusions on the validity of these paranoid thoughts?
They were not true.
What paranoia did Timothy express on October 17th, 2018?
He thought that his wife told their son Nathan to intentionally spill juice on his laptop in order to sabotage him.
And what were your conclusions on the validity of these paranoid thoughts?
They were not true.
What paranoia did Timothy express during his interactions with Officer Wentz?
Mr. Ray repeatedly asked Officer Wentz if he was with the CIA.
And what were your conclusions on the validity of these paranoid thoughts?
They were not true.
And finally, what paranoia did Timothy Ray express to you in your clinical interview?
He accused me of being a government agent and thought that there was a camera in the microwave of my office. He was also paranoid that his wife and son were going to cut him up with a knife and leave him.
And what were your conclusions on the validity of these paranoid thoughts?
Those were also not true.
What about hallucinations? What hallucinations did Mr. Ray exhibit?
He reported auditory hallucinations beginning when he was 10 years old and visual hallucinations as early as 2010 when he was discharged from the Army. These symptoms were on and off, but I noted that Mr. Ray had sporadic visual and auditory hallucinations in 2017 and also in October of 2018.
How did Timothy describe the visual hallucinations leading up to October 2018?
He described them as triangles on the wall that changed shapes and colors.
How about the auditory hallucinations leading up to October 2018?
He reported hearing male voices that would randomly pop up and tell him to hurt other people.
And how did he describe the auditory hallucinations on the day of October 17th, 2018?
Mr. Ray reported hearing a creepy voice that told him to kill his son for acting out and that Nathan spilled the juice on purpose in order to sabotage him.
And finally, what negative symptoms did Mr. Ray show?
It was clear to me that Mr. Ray suffered from negative symptoms when he demonstrated angry outbursts during our interview and had episodes of crying. I learned that Mr. Ray had a social phobia related to locking himself in the bathroom and had also always had issues with mood swings. In addition, Mr. Ray has been consistently seen to be in a disheveled look, as though he hasn't showered or taken care of himself in a few weeks.
And who all witnessed these negative symptoms?
These negative symptoms were witnessed by his wife, his coworkers, Detective Booth, Officer Wentz, and also by me.
Has Mr. Ray ever been formally diagnosed with schizophrenia?
No, he has not received a formal diagnosis, but I do believe that Mr. Ray was suffering from symptoms consistent with schizophrenia as of October 17th, 2018.
Why did you not diagnose Timothy Ray in your clinical interview?
My job here was not to diagnose or provide treatment to Mr. Ray. It was to analyze whether his symptoms were consistent with this diagnosis.
And what medication is Mr. Ray taking?
Mr. Ray is taking 300 milligrams of Seroquel.
Your Honor, defense would like to make judicial notice of stipulation 7.
I may read it into the record.
I'm sorry, Your Honor.
You may read it into the record if you like.
Yes. Seroquel is an antipsychotic used to treat certain mental conditions and mood conditions. Seroquel can be used to treat schizophrenia, bipolar disorder, and sudden episodes of mania or depression associated with bipolar disorder. A prescription of 300 milligrams of Seroquel can be used to treat any of these conditions. Dr. Riley, why is it important to identify if someone was suffering from severe mental illness such as schizophrenia?
Because mental illness, like schizophrenia, can impair a person's ability to understand the nature of their actions. Simply stated, a person who is suffering from severe schizophrenia might not be able to understand right from wrong in their actions.
Thank you. I have no further questions.
May I proceed, Your Honor? Your Honor, may I proceed?
Just 1 second. It looks like he may have just gotten kicked off. Okay.
Yes.
Hey guys, he's rebooting right now, and it looks like someone else is requesting a short break. So why don't we just take 5 minutes, okay? Come back here at 5:21. All right.
Yes.
Thanks. Jared, are you back? You're on mute. We can't hear you. I don't know if you're talking, Jared, but we can't hear you yet. We still can't hear you. Can you hear me, Jared? Advocates, can you hear Jared? Or Judge Hatcliffe?
We cannot.
Okay. Judge, we still don't have you.
Can you guys hear me?
Yes.
Yes,
Now we
Your
can.
I'm so sorry. I'm really very, very, very sorry. I got kicked off, and I don't know. It's the first time I've gotten kicked off in a while, so I do apologize. And Braden, I think that you were still on your direct towards the end, but pick it up from wherever you left off.
Just one moment, please. Would you like me to find the point that I last lost you? I actually made it through my whole.
Oh, you did? Okay. I think that I was kind of towards the end, so as long as the jurors heard you, it's fine. And if you're ready to hand it off to Cross, that's fine.
Yeah, I'm prepared to do that. Yeah.
All right. Thank you. Again, I'm sorry.
May I proceed with Cross, Your Honor?
Please.
Yes. Dr. Riley, you are the only doctor who has ever said the defendant had schizophrenia.
Yes, that's correct.
And you came to this conclusion in September of 2019.
Yes, that's correct.
While the defendant was in jail.
Yes.
Where he had been for nearly a year awaiting this trial for killing his son.
Yes.
Dr. Riley, it was in this interview with him that he claimed symptoms of schizophrenia.
Yes, he did tell me about his symptoms of schizophrenia at that time.
He claimed that he was having hallucinations.
He did say that, yes.
He claimed that he was having delusions.
Yes, he did.
He claimed that he was hearing voices.
Yes, he did say that he was hearing voices.
Now, Dr. Riley, the defendant had never claimed any of these symptoms of schizophrenia before.
As I stated in my testimony, he had good reason not to claim them, so he did not state them to anyone before.
Now, Dr. Riley, 2019 was not the first time that you evaluated the defendant. You evaluated him in 2010.
I did evaluate him in 2010.
And in 2010, it was your professional medical opinion that the defendant was not suffering from schizophrenia.
At that time, based on the information, the limited amount of information that I was given, yes, that's correct.
Because the defendant denied hearing voices.
As I said earlier, he had good reason to deny those symptoms, but yes, he did deny them.
He denied having hallucinations.
Yes, he denied hallucinations.
And he denied having delusions.
Again, he did deny those because he was afraid of being labeled crazy like his mom.
So in 2010, it was your professional medical opinion that the defendant had general anxiety disorder.
Yes, that was my opinion at that time.
You diagnosed him with general anxiety disorder, not schizophrenia.
It's not uncommon for mental illness to progress over a person's lifetime or for more information to become available. So in 2010, I did diagnose him with generalized anxiety disorder, but this is not an uncommon situation for a disease process to progress the way his has.
Now, Dr. Riley, I did not ask you about the commonality. I said in 2010, you diagnosed the defendant with general anxiety disorder, correct?
Yes, I did answer that in my statement. He was diagnosed with that at that time.
He was diagnosed with general anxiety disorder, not schizophrenia.
That's correct.
So, Dr. Riley, it was not until 2019 when the defendant paid you to evaluate him in preparation of this trial that you diagnosed him with schizophrenia.
Yes, that was the next time that I had an opportunity to evaluate him. So yes, that was when I diagnosed him with schizophrenia.
Well, Dr. Riley, you are aware that you are not the only doctor the defendant has seen.
Yes, I reviewed all the files from Dr. DiGiuseppe and his doctor when he was in prison.
So you know that Dr. DiGiuseppe saw the defendant 3 different times.
Yes, that's correct.
But Dr. DiGiuseppe never diagnosed the defendant with any mental illness.
As Dr. DiGiuseppe noted in her deposition, she said that she didn't feel comfortable handling mental illness all the time, so she referred him to a psychiatrist at their last visit.
But Dr. DiGiuseppe did not diagnose the defendant with any mental illness.
That's correct.
And then the defendant saw a different doctor just a month after you had diagnosed him with schizophrenia while he was in prison.
Yes, that's correct. As
And
a
to
prison doctor.
And to this doctor in prison, he denied having hallucinations.
As I said in my direct examination, symptoms of schizophrenia can come and go over a person's lifetime. So that wasn't surprising to me to read that he did not report hallucinations at that time.
Well, Dr. Riley, that was not my question. To this doctor, just a month after you had diagnosed him, the defendant did not report having hallucinations.
That's correct. He didn't report hallucinations at that time.
He did not report having delusions.
That's correct.
And he did not report hearing voices.
Yes, that's correct.
And this doctor did not diagnose the defendant with any mental illness.
Although she prescribed him a medication that could be used to treat the illness that I have diagnosed him with, she did not give him a formal diagnosis of schizophrenia.
Now, Dr. Riley, let's talk about your evaluation of the defendant while he was in prison. You said that for a majority of this interview, the defendant appeared fine.
Yes, he did.
You said that he spoke eloquently.
Yes, he did.
Appeared very coherent.
Yes, he spoke eloquently and coherently.
But you also said that he was suffering from schizophrenia.
Yes, the two are not mutually exclusive.
You said that he was suffering from schizophrenia, a disease that you said he inherited from his mother.
It's not possible for me to say that he actually inherited the disease, but he was at higher risk because his mother showed symptoms of mental illness also.
So at higher risk, but you have never evaluated the defendant's mother.
Unfortunately, the defendant's mother is dead. She's no longer living, so I would not have had that opportunity to evaluate her.
So you never met her?
That's correct.
You never even saw any of her medical records?
None were made available to any of the experts in this case, I believe.
So, Dr. Riley, you have no idea whether the defendant's mother was ever actually diagnosed with any mental illness?
As is common in psychiatric evaluations, I did interview the defendant's father, but that's the only information I have. And I think that's the only information anyone in this trial has is what we were.
Objection, Your Honor. Move to strike as non-responsive.
I'll strike that last portion, but the first portion shall remain. Thank you.
Yes, Your Honor. Now, Dr. Riley, directing you back to my question. You do not know if the defendant's mother was ever diagnosed with any mental illness, correct?
That's correct.
Your Honor. Asked and answered.
Overruled.
Now, Dr. Riley, you are an expert, so you are familiar with malingering.
Yes, I am.
Essentially, that is faking symptoms.
Yes.
Now, Dr. Riley, you know that one of the signs of faking symptoms is the inability to keep your story straight.
It could be one of the signs, but
And you know that the defendant repeatedly told Detective Booth that he killed Nathan in Nathan's bedroom.
yes, that's correct.
But he told you that he killed Nathan in the kitchen.
Yes, he did say that.
Now, Dr. Riley, you know that another sign of malingering is acting out in police presence.
Again, that does not diagnose malingering, but it could contribute to it, yes.
And you know that when Detective Booth started to question the defendant, that he began to scream.
Yes, I believe he did do that.
That he began to cry uncontrollably.
Yes, he did.
Now, Dr. Riley, you know that another sign of malingering is exhibiting symptoms that you never have before.
Yes, symptoms that are inconsistent with the past, yes.
And we have already established that 2019 was the first time that this defendant displayed many symptoms of schizophrenia.
Yes.
Now, Dr. Riley, you said that there is always the possibility of malingering.
Of course, in any patient in psychiatry or general medicine, we always have to consider that malingering is a possibility, but in a large majority of cases, it's not.
You said that the worse the crime, the higher the likelihood that the defendant is faking it to get out of trouble.
Yes, I did say that.
Nothing further.
Redirect.
No, Your Honor. The defense rests.
All right. Thank you very much. Major Riley, thank you for your time. And we prepared to move to closings.
Yes, Your Honor, but prior to starting our closing arguments, we request a 5-minute brief break.
Of course. I will see you back at 6:40.
Yes, Your Honor.
Okay. Just make sure that we got all our jurors back. Great. 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 We got all three, and I'm here. So we want to get a time check before we start.
Yes, Your Honor.
Okay.
The prosecution has used 45 minutes and 20 seconds. They have 9 minutes and 40 seconds for their closing argument and rebuttal.
And the defense has, let me just check the spreadsheet. The defense has 14 minutes and 47 seconds remaining.
So prosecution, would you like to reserve any time for rebuttal?
Yes, Your Honor. We ask that any remaining time be reserved for our rebuttal.
Okay, fair enough.
Your Honor, if I may, there's been a request from the defense that they be alerted at 5, 2, and 1 minutes remaining. Would it be possible for me to turn my camera on to flash those warnings, or how would you prefer to handle that?
You can either turn your camera on and flash it, or you could just pop on. You don't need to put your video on. You could just, kind of come in and say it. It's up to you, but I have no issue with that.
I'll do the camera if that's okay.
That's fine. Okay, so I'll leave it to you all whenever you're ready, Madam Prosecutor. I think that we want to go back to speaker view.
Members of the jury, today the defense stood before you and tried to put on a smoke and mirror show, making today's case about mental illness, about whether or not this defendant was suffering from schizophrenia when he strangled his son to death. But y'all, let's not forget that on October 17th, 2018, Jessica Ray lost her only baby at the hands of her very own husband. Let's not forget that on October 17th, 2018, this defendant took his belt and wrapped it around his 6-year-old son's neck and watched as the life left his little body. Let's not forget that on October 17th, 2018, this defendant strangled his own son to death. Members of the jury, the state of West Carolina has charged this defendant with first-degree murder. And as the state, as the party bringing this charge, it was our burden to prove to you today beyond a reasonable doubt that this defendant is guilty. We gladly accept that burden, because what the overwhelming amount of evidence in today's case has shown is that not only did this defendant kill his son, but he did so knowingly, willfully, and intentionally. So how did we prove our case today? Today you heard from Detective Booth, who took the stand today as the lead homicide investigator responsible for investigating just who killed Nathan Ray. Detective Booth told you that after making sure that this defendant understood his rights, after having this defendant sign his Miranda waiver, you know what he said? I understand. I want to tell you everything. Why would this defendant want to tell Detective Booth everything? Because he was so guilt-ridden by what he had just done to his own son that he knew he had to tell the truth. What was that truth? It was in this interview that the defendant admitted to wrapping his belt around his son's neck. The defendant admitted to pulling that belt so tight that Nathan stopped breathing. The defendant admitted to wrapping his son's dead body in a garbage bag and tossing him in the backseat of his car. The defendant admitted to driving his son's dead body to Brandywine State Park. The defendant admitted to digging his own son's shallow grave. Members of the jury, the defendant admitted to tossing Nathan's lifeless body in that grave, tossing just a little bit of dirt on top and leaving him to rot. Because of that confession, there is no question as to who killed Nathan Ray. Which means the only thing that we had to prove today is whether or not Nathan's death was premeditated. Members of the jury, the judge explained that premeditation can happen in an instant. There is no set amount of time for premeditation to occur. The decision to kill can be made in seconds. Y'all, today you learned that this defendant was so angry that he walked out of Nathan's room, walked into his own, and tried to calm down. But this defendant could not calm down. When he grabbed his belt, he was calculated. And members of the jury, when this defendant walked into Nathan's room, he was in control. And y'all, there was only one thing on this defendant's mind when he wrapped his belt around his son's neck. In that moment, this defendant was committed to killing his own son. Y'all, you do not wrap a belt around a child's neck unless you intend to kill them. That moment that this defendant confesses to, that is premeditation. Which is why you must find this defendant guilty of first-degree murder. Period. But instead, the defense stood up here today and tried to tell you that this defendant, he did not understand that what he did was wrong. The defense tried to tell you that this defendant did not understand the consequences of his actions. And in doing so, the judge explained that this is what is called an affirmative defense. The defense bore the burden of proving to you today that not only did this defendant suffer from a severe mental illness, but when he strangled his son to death, he was unable to understand the nature and consequences of his actions. The defense cannot and will not meet that burden today. You saw his search history. Do people who do not understand that what they did was wrong Google how to get rid of a body? Do people who do not understand the consequences of their actions Google countries that don't extradite for murder? Absolutely not. But that is exactly what this defendant did. After strangling his son to death, this defendant got out his cell phone. He opened up Google and Googled, does bleach destroy a body? He Googled how to get rid of a body. He even Googled what countries don't extradite for murder. This defendant Googled exactly how to get away with killing Nathan Ray. If this defendant truly could not understand that what he did was wrong, why did he try to hide it? If this defendant truly did not understand the consequences of his actions, why did he drag his son's dead body through Brandywine State Park and toss him out as if he was trash? I'll tell you why. Because he is committed. He is committed to getting away with murder. So committed that today y'all met Dr. Riley. Dr. Riley, the same doctor who diagnosed this defendant with general anxiety disorder in 2010. So how did she reach her diagnosis today? Based on statements made by this defendant in 2019. You see, after sitting in jail for almost a year for murder, this defendant realized he'd already confessed. There was only one way out. So his lawyers called Dr. Riley. You saw Dr. Riley on the stand today. She read everything that the defense needed her to say. Members of the jury, it was not until 2019, while sitting in a jail cell, that this defendant ever claimed to hear voices, that he ever claimed to suffer from hallucinations. It was not until 2019, while sitting in jail for murdering his own son, that this defendant ever admitted to any of the symptoms consistent with a schizophrenia diagnosis. And why is that? It's because this defendant is not schizophrenic. He just needs you to think that he is. Members of the jury, on October 17th, 2018, just like he is today, this defendant is calculated. He is controlled, and he is committed to getting away with murder. The defendant is guilty. Find him guilty. Thank you, Your Honor.
Thank you, Counselor. Are we ready to go to closings, Madam Defendant?
We're ready for defense close, Your Honor.
All right, you may proceed when you're ready.
May it please the court, Your Honor, opposing counsel, members of the jury, you cannot stop what you cannot control. At the beginning of trial, my co-counsel, Mr. Hodek, explained to us who the defendant, Mr. Ray, was, and how Mr. Ray could not stop what he could not control. Mr. Ray could not stop his past trauma that he grew up with. He could not stop suffering from a mental illness, and he could not stop the voices that he heard on October 17, 2018. Now, today's case focuses on a very real problem in our country: mental illness. Mental illness is something that should be talked about more openly. Why? Because nearly 1 in 5 Americans suffer from some sort of anxiety disorder. That's scary, because anxiety disorder experienced as a young man can worsen and even lead to a more serious mental illness, like schizophrenia. Now, before we get into what we heard, I want to remind you all what you are deciding. As the jury, you're deciding whether Mr. Ray committed first-degree murder. This charge has a heavy burden. It's the highest burden in a criminal trial, and that burden rests on the prosecution. The prosecution had to prove to you every element of the crime beyond a reasonable doubt. Beyond a reasonable doubt means a doubt that would cause a reasonable person to pause or hesitate when making an important decision in their life. They had to meet that burden for every element. First, that there was a death. And tragically, Mr. Ray lost his son on October 17, 2018. Second, is that the death was caused by the defendant. And third, that there was malice aforethought. Now, this is legal jargon that may be confusing, but you're answering a simple question. Did Mr. Ray willfully, deliberately, or intentionally act in order to kill his son? After all the facts and evidence that came in at trial today, we see that the prosecution failed to meet their burden. Because of that, you must find Mr. Ray not guilty. Now, in addition to evaluating the evidence, you, the jury, also get to evaluate credibility. Credibility of the witnesses you heard today. And what did you hear? Members of the jury, while prosecution would like you to believe that Mr. Ray was the one who was calculated, controlled, and committed, we saw that, in fact, it was Detective Booth who was these things. As lead detective, he calculated what evidence to collect. And one very important evidence Detective Booth decided not to save is a copy of the audio and video of his interview with Mr. Ray when he was arrested. A video that would have shown how Mr. Ray was suffering that night. Detective Booth controlled this whole investigation, and he committed to only one suspect, Mr. Ray. Another witness the prosecution brought forth was Dr. LaGreca, a forensic psychiatrist, who stated on the stand, "I have no idea what's going on in Mr. Ray's head." And yet Dr. LaGreca would like us to believe that Mr. Ray was malingering? A doctor who could remember statistics on malingering and schizophrenia, but when asked about a common statistic on anxiety, he was not certain. A doctor who couldn't remember the DSM-5 factors listed for malingering. He wants you to believe him when he cannot remember the facts he used to come to his conclusion. Now, what the prosecution failed to prove was malice aforethought. Did Mr. Ray decide to kill his son? Prosecution has failed to prove that. Mr. Ray decided to kill his son. That in the moment of the accident, Mr. Ray meant to kill his son. And we heard what happened that day. Mr. Ray was getting his son ready for school. Unlike when he was a child, Mr. Ray made sure his son had a meal that morning. And as his son finished his cereal, was finishing his juice, Mr. Ray was getting his work things in order. While his laptop was on the table ready to go, things turned sour when his son spilled juice on Mr. Ray's laptop. Before he could react, a voice tells Mr. Ray that he has to punish his son because his actions were intentional. When he had to remember the horrible events that occurred on October 17, 2018, he told the detective, "I didn't mean to." These voices that Mr. Ray hears pushed him to punish his son, that he needed to make his son understand. And that is when tragedy occurred, as Mr. Ray could not stop, but he could not control. From all the evidence we heard today, what did we not hear? That Mr. Ray decided to kill his son, that Mr. Ray intentionally killed his son, that Mr. Ray willfully killed his son. Members of the jury, this was not a malicious murder. This was a parent suffering from a mental illness he could not control, which caused him to lose his child. Now, in the end, if you find the prosecution has met their burden, the defense has brought sufficient evidence to prove an insanity defense. To meet our burden, the defense needed to prove by clear and convincing evidence 2 elements. First, that Mr. Ray suffered from a severe mental illness. And second, that severe mental illness made Mr. Ray unable to appreciate his actions. Now, clear and convincing evidence is a much lower burden than beyond a reasonable doubt. Unlike the prosecution, we do not need to push down a brick wall of evidence. Rather, we simply have to show that it was highly probable that Mr. Ray suffered from a mental illness that made him unable to appreciate his actions on October 17, 2018. Through clear and convincing evidence, we, the defense, have proven this, that Mr. Ray's actions were the result of a severe mental disease that Mr. Ray could not control. A severe mental illness with symptoms consistent with schizophrenia. Second, that the mental illness Mr. Ray was suffering made him unable to understand what he was really doing. We heard from Dr. Riley today, someone who suffers from schizophrenia would not be able to understand their actions. Now, members of the jury, we heard from 2 expert witnesses today, Dr. LaGreca and Dr. Riley, who both identified that mental illness is a problem, that mental illness at a young age can worsen as time progresses. Untreated mental illness can worsen. In addition, we learned that Mr. Ray was predisposed to having a severe mental illness by family history, past diagnosis of mental illness, and trauma. Now, when we go to the doctors, we're all met with those forms we have to fill before seeing the doctor. The forms that ask basic questions of age, residency, and family history. Why? Because family history helps doctors identify potential risks for a patient. Family history of mental illness can increase the risk of a mental illness in a child. While his father and relatives may not have suffered any mental illness, we are aware that Mr. Ray's mother was. From Dr. Riley's interview with Mr. Ray's father, Abe Ray, Dr. Riley learned that Mr. Ray's mother was suffering from a severe mental disorder and was institutionalized. Mr. Ray could not control his mother's suffering as she fought with mental illness. And he could not control how people labeled his mother, but he could control what people thought of him. Mr. Ray did not want to be labeled crazy like his mother. Mr. Ray tried to control people's perception of him and tried to hide his suffering. While he tried to hide his suffering, he ultimately could not hide it. In 2009, Mr. Ray joined the Army. However, before he could serve his country, Mr. Ray was discharged from that Army. It was at this time he was formally diagnosed with general anxiety disorder. While given medication and instructions to follow up with his primary care physician, we cannot say for certain if he followed that recommendation. However, we did hear that anxiety disorder experienced as a young man can worsen to a more serious mental illness. Another factor was trauma. Dr. Riley and Dr. LaGreca told us childhood trauma can make a person more likely to develop severe mental illness. Mr. Ray could not control the abuse he received from his mother. Until he was 3 years old, Mr. Ray was inconsistently fed, bathed in ice-cold water, and in the end abandoned by his own mother. Mr. Ray experienced major childhood trauma that he could not control, and that led him to have an increased risk of suffering from a severe mental illness. While never formally diagnosed with schizophrenia, defense has brought in ample evidence to show that Mr. Ray was suffering, that he was suffering a mental illness that could be consistent with schizophrenia. Now, to be diagnosed with schizophrenia, a patient must show 2 or more factors listed in the DSM-5. After hearing all the evidence today, we see that building up to October 17, 2018, Mr. Ray had shown symptoms consistent with 3 of the 5 factors: hallucination, delusions, and negative symptoms. We can see the progression of Mr. Ray's suffering from Dr. Riley's testimony. Since he was 10 years old, Mr. Ray suffered from auditory hallucinations or voices. While these voices may have been sporadic, Mr. Ray grew up, and months leading up to October 17th, the voices returned. He constantly labeled these voices as they. And even during his interview with Detective Booth, Mr. Ray identified these voices again. These voices that told him his wife tricked their son. They told him that his son did it on purpose and was trying to sabotage him. And they told him that he needed to make his son understand. Members of the jury, does this sound like a man who's thinking clearly? Or does it sound like a man suffering from a mental disorder he could not control from the beginning? We learned about the delusions Mr. Ray suffered from, the paranoid statements that he made, where he thought the CIA was after him, that the CIA sirens were coming to get him. Mr. Ray's paranoia continued as he was interviewed by Dr. Riley, and Mr. Ray thought there was a camera in the microwave. When Mr. Ray visited Dr. DiGiuseppe, he was paranoid that Dr. DiGiuseppe was speaking with his wife without his knowledge, conspiring against Mr. Ray. Mr. Ray was paranoid when he believed his wife and son would cut him up with a knife and leave him. Dr. Riley identified these examples as delusions, and she labeled them these because they had no validity or truth to them. Finally, negative symptoms. Mr. Ray had a problem sleeping since he had joined the Army in 2009. There was consistent evidence of Mr. Ray having moments of angry outbursts during interviews. There were times during his interview with Dr. Riley and Dr. DiGiuseppe prior to October 2018, where Mr. Ray had anger outbursts and uncontrollable crying. And in addition, he had a negative symptom of lack of hygiene. When he took his son to soccer practice, other parents noticed how Mr. Ray was disheveled, hair messy, and a strong reek of body odor. This did not change when Mr. Ray was arrested on October 19, 2018. Officer Wentz noticed right away something was off with Mr. Ray. He was disheveled, hair messy, and had a strong, overwhelming body odor. Now, meanwhile, members of the jury, while Mr. Ray was never formally diagnosed with schizophrenia, he is currently prescribed medication to treat mental and mood conditions consistent with schizophrenia, bipolar disorder, and mania or depression. As we look through Mr. Ray's history, we saw that he has 3 of the 5 factors that are consistent with schizophrenia. Mr. Ray suffered a severe mental illness leading up to October 17, 2018. And this is important because we learned how people who experience severe symptoms of mental illness, like schizophrenia, well, that can impair their ability to understand the nature of their action, which includes the ability to understand right from wrong. Now, as we look at the totality of the evidence, we see Mr. Ray could not stop what he could not control. Could not control the abuse and neglect he received as a child, could not control the suffering from a mental illness. He could not control being diagnosed with general anxiety disorder, and he could not hear the voices he heard on October 17, 2018. In the end, we see that Mr. Ray could not stop nor control his suffering, which led to the unfortunate events leading us here today. We ask that you find the defendant, Mr. Ray, not guilty of first-degree murder.
Thank you, Counselor. Any rebuttal?
Yes, Your Honor.
Proceed.
Members of the jury, defense counsel just stood up here and told you that this defendant could not control what was going on. But y'all, he controlled the belt he picked up out of his closet. He controlled how long he wrapped that belt around little Nathan's neck. He controlled exactly how he disposed of that body. This defendant was in control from start to finish. Y'all, the defense also tried to tell you that this man was suffering. But you know who suffered? Nathan Ray, when his dad wrapped his belt around his neck and strangled him to death. Members of the jury, this defendant does not have schizophrenia. This defendant just thinks he's smart enough to get away with murder. The defendant is guilty of first-degree murder. Find him guilty. Thank you, Your Honor.
Thank you, Counselor. Well, that was really amazing. You should really be proud of yourselves. Really, really just fantastic. We're gonna just take a couple of seconds to let the judges submit their ballots and then get some feedback and stuff like that. So if you want to take 60 seconds to, use the restroom or whatever, that's fine. I'm not going anywhere, but just really fantastic, all of you. So
Thank you, Your Honor.
We'll get back as soon as I get the all clear. All right. Hey guys. All right, so I have not yet gotten the okay, but then the jurors that are here, did you all submit? Everybody submitted? Jurors, you can, I think you can, you can just stay on now if you want. Everybody submitted?
Yes, Your Honor.
All right. All right, I just got the clear. So, Ms. Baxter, why don't you go ahead first?
Good afternoon, Your Honor, and advocates. The future is bright. I've practiced for a number of years. I started out doing criminal defense in Philadelphia, and I'm a native Texan. So I now do civil litigation, commercial litigation in Texas. I am an attorney with the office of McCory Veselka, Bragg and Allen, and I also am an adjunct with the University of Texas. I want to tell you all that this is, having practiced so long, this is a whole new journey for all of us. And you guys are coming out of the gates ready for the next phase. There are only two comments we can make. To the defense, great job. Be prepared when you take someone on voir dire, come out of the gate ready. To the prosecution, mental health is a real issue. So as strongly as you advocate for your client's position, you've got to give some credence to the fact that there are a number of people who have undiagnosed mental health issues. So I just want, if you guys are fortunate to move forward, remember those two things, but overall, great job. And I'm honored, I am very honored to have been able to watch you guys.
Thank you, Sharon. Who wants to go next?
I'll go. I thought you guys did a great job. My name's Sarah Johnson. I do coach trial teams, and so it was a pleasure watching you. Like I said, I do this on a regular basis, and you guys do an excellent job. I am just going to go a little bit more in depth. Elizabeth, I love the drama and emotion that you showed. Be a little careful on the cross. You came out just a little bit, it sounded scripted. So if you could just be a little more conversational and kind of listen to their answers and not maybe think so much about the next question coming. Jessica, I thought you did an excellent job in incorporating the facts and theme from opposing counsel into your closing. That was awesome. Great job. On cross-examination, I think that we need a little more context to understand the significance of some of the questions you were asking, because without having that context, it didn't quite make sense. Brayden, I thought you had a great conversational style. I liked your calmness and demeanor. I think that you need to work on identifying and responding to objections. And Alex, I think that you did an excellent job listening and incorporating answers into your, especially in your cross-examination, but in both of your examinations. I love your passion. I think you need to keep every aspect of it. But sometimes when you're at max level for the entire time, you can lose effect a little bit. But again, don't lose it because it's excellent. But that's my feedback. Nice job.
Taylor?
Okay, so my name is Taylor Gerchman. I just recently started my own solo practice in Pennsylvania. I went to Drexel University School of Law. I was on the trial team there, so it hasn't been that long since I was in your shoes, so I get it. We didn't do it during via Zoom when I was on trial team, but it's still nerve-wracking nonetheless. So I just have like one comment for each person. Elizabeth, I wrote that you were a very good advocate. Just loosen up a little bit. It seemed like you were a little bit stiff at certain parts. So just loosen up a little bit, have more of a conversation. Alex, I thought you were an exceptional advocate. I really did. I loved that you carried your tone throughout the entire thing, that you were just like indignant about what happened to this young child. And I thought that was great. It made me believe that you believed in your case. The only thing I would say about that is be careful about the way that you prep your witness. I thought your witness was a little bit more confrontational than he needed to be. Brayden, I thought you were super likable. I liked the tone that you had for the most part, but I do think that you need to vary it a little bit when you come to some appropriate parts during the trial. I think that you can you can vary your tone a little bit more and it would be really effective for the jury. And then Jessica, I thought you really shined during your closing. But I wish that you would have brought that personality into some of the other parts that you had during the trial. I saw that like great, like very very persuasive tone about you. And I wish I would have seen more of that. But overall, I think you guys did such a great job. Good job.
Thank you.
Yeah. So since we don't have to go run into one more courtroom, and I'm sure you're all exhausted, if you don't mind, I'm just going to take a couple of minutes to give you some feedback as well, because I just think that you are all incredible. But if you don't want to stay because you're tired, I get that too. I don't know if some of you had to perform twice today, but so those of you that are shaking your head, my heart goes out to you, because I know that one of my teams had to go twice today, and I know they're dragging it right now. So total kudos to you. My name, again, you can see, is Jared Hatcliffe. I'm a trial attorney for the city of New York, and I also teach law school. I've taught at the college level and law school level, and I teach trial advocacy, motion practice, and also coach trial teams, obviously. And I've done that at high school, college, and law school. And the reason that I love to do this is to see people like all of you, because you're amazing. You really are. So I try cases. I represent police officers who are accused of excessive force. So it's busy, especially in the city of New York, and I can see both sides of your coins, because I see the prosecution, because I represent police officers, but defendants, I see your side too, because usually my clients are not very likable because they've been accused of shooting somebody or hurting somebody. So I understand both of your sides, but I can tell you right now that all four of you are better than half of the advocates that I've gone up a trial against. You're just really amazing, and you should be super proud of yourself. And again, one of the reasons that I really enjoy doing this is to see the next generation and all of you. So specifically, I just want to say that, it stinks being on Zoom, right? I mean, we'd much rather be in person, because it's so hard to Zoom energy and so hard to Zoom passion, right? And you want to be in front of the jury. And I know how you feel. But this experience has taught us that we have to rethink some of the ways that we have to communicate. And you all did a really, really nice job using the technology to get your points across, especially with the PowerPoint, Alex, that you used. That was one of the best PowerPoints that I've seen thus far. And I'm a big believer in that people are visual learners, right? If you're just talking, you're only teaching people half the way. And as a trial attorney, we're teachers, right? We're just not attorneys. We're teachers, we're salespeople, we're all a bunch of different things. And you just really did it very nicely. All of you did, because I could see how you all cared and how much you worked. So I'm just going to go one by one. Alex, I'll just start with you, because you had a lot of really great things. I thought that direct of the expert was one of the best directs that I've seen all weekend, to be honest. And just the way you use the technology and your demeanor is just really, really fantastic. Your cross of Wentz also, that's a difficult cross, because basically the defense is calling they're calling your cop, right? So you can't attack the cop, because it's really but you still did it in a fantastic way about showing that this person really is not qualified in order to make the diagnosis that they're trying to bring out and say he's making. And I just thought it was really, really well done. And throughout your closing, very passionate as well. You tend to say y'all a lot, and I think it's just so. I just thought it was really great. Like, I loved it. It was kind of like your charm and your way of doing things. And I think you said y'all like 5 times. Like, come on, y'all. You know that this guy is guilty, and I just loved the way you did it. So really fantastic. All right, Jessica. So you had your closing was also really good, and it was very a different type of closing than Alex's, right? Very different styles, which can show you that you should always be yourself. And being yourself is the most important thing, because when you're true to yourself, that's when jurors are going to believe you. and you had a very different style, and I liked your closing. But what I really loved what you did was when you were crossing the expert witness, because let's face it, that expert was tough. And I was sitting there and the Greco was cruising along. And then all of a sudden he gave you an opportunity, and you took that opportunity and you really, you shoved it right back at him. And then you also, you did a good job when you were directing Officer Wentz when the dog was barking, and you just didn't bother you at all. Because I wanted to kind of laugh in the background when the dog was barking, but you just stayed cool and calm the entire time. But I really did love your cross-examination, because you brought out the malingering in the DSM. That's what you did, right? Because he was saying, oh, I don't know what these 4 factors are listed in the DSM, and you brought it out, and you showed us that he should really know what the 4 factors are. So you did really well with that. And then Alex, you did great by not running away from the problem and then attacking it back on redirect. So I just thought, you two just did a fantastic job there. Brendan, I thought that your opening, I loved your opening. And when you said, did the prosecution just want to say what Timothy Ray is? And you said, now I want to show you who Timothy Ray is. And as soon as you did that, like you hooked me in, and then I wanted to listen to your story about who Timothy Ray was and why he became, an unlikable person, right? He's not a very likable person, but he's a sick person. And you told that story. And what I also say is that I wrote down in my notes, you have this like mild-mannered personality, like a Clark Kent. Like I kept waiting for you to pull this S, get the S out, because you just have like such a great personality. And, that trustworthiness that you have, I think jurors are going to like. And, I think Taylor said it before that, you're all very likable. And I think personally, that's the most important thing that you need to have as a trial attorney, because if a jury likes you, they're never going to hurt you. You may lose, but you're never going to get hurt. So, and you definitely have that. And Elizabeth, that direct of Booth, fantastic. Beyond that was just so, because Booth is not a likable person. And I liked Booth because I've read this fact pattern like 300 times, right? And Booth's really not a great guy. He's just not. I mean, but you made me like Booth a lot. Now, I just want to ask you one question. So when I wasn't trying to give you a hard time about the excited utterance. I was really trying to give you an opportunity to argue it, because I wasn't sure how I was going to argue, because you were right when you said, hey, they did not establish that she was under, some kind of emotional distress. So when I said, can we agree? You could have said no, because people handle things differently. So I wasn't trying to give you a hard time. I was just kind of trying to explore it with you.
Sure.
So again, I just thought you were all amazing, and it's just such a pleasure to watch you all. And if you are ever in New York, I think that you're kind of like far across the country from where I am in New York. But if you have any desire to ever work for the city of New York, because we have a lot of employees, please look me up. I'd be happy to put you in touch with the legal coordinator. And you're really all amazing, and just a really fantastic job. Much more advanced than where I was when I was your age. So,
Thanks, Your Honor.
Any questions? No? All right then. Thank you. Taylor, thank you.
Everyone.
Thanks, y'all.
Thank you.
Thank you all.
Good luck moving forward.
Thank you.